This meeting is being transcribed. This meeting is being recorded.
Call to order.
Thank you very much. And members, just to make sure whenever you are speaking, if you can make sure your button is red. Sometimes the mics are sensitive, sometimes they're not. So I'll try to remind you. Today is Monday, June the 5th. This is the regularly scheduled Cosmetology and Barber Examiners Board meeting. The agenda has been on the website since June the 1st of 2023. And prior to that, on August 2nd, 2022, all of our meeting dates were also updated. By roll call vote to establish quorum, if you could say yes when I get to your name. Chairman Ron Gillihan?
Yes.
Ms. Becky Russell is not here with us today. Judy McAllister?
Yes.
Patricia Parsons?
Yes.
Mona Sappenfield is also not here today. Amy Tanksley?
Yes.
Thank you. Frank Gambusa? I believe Mr. Gambusa will be joining us shortly. Anita Charlton? Lane Petty?
Yes.
Monica Lemons?
Yes.
Jeffrey Moran is also not here today. David McElreath.
Yes.
Thank you. And thank you, members, for being here. We have quorum in order to proceed. Chairman Gillihan, I'll turn it over to you.
Good morning. And again, we'll acknowledge our guests and welcome you one more time to for having stopped in with us this morning. Thank you for being here. We won't have anybody participating as a member on telephone today? Okay.
We're all here.
Okay. At this time, we will need to have an approval of the April 2023 minutes. Are there any additions, corrections, or deletions? Hearing none, do we have a motion?
So moved.
Second.
We have a motion properly seconded to approve the minutes of the 2023 April meeting. All in favor say aye.
Aye.
Motion carries. Ms. Roxana, on the next item, it looks like legislative updates.
Yes, sir.
Now.
If you're okay, Chairman Gillihan, we're going to move the legislative updates to the end under new board business. We have 3 public chapters that passed this session that impact the industry, so we're going to discuss those, and that way Hugh can update everything, and we'll go into the draft rules for the new law, if that's okay.
That's absolutely fine. So that will bring us up to schools.
Got it. Thank you. And welcome to our school owners and administrators that are participating. The first item on our agenda is Career Beauty College. This is a name change only. I believe Ms. Janice Roberts or someone from her school is participating to answer any questions. The school plans to change the name from Career Beauty College to Lawrenceburg Technical College. It's simply a name change. The board has given me authority to approve those in between meetings as long as they're only for accreditation purposes for the LLC. This is an actual name change, so we simply need a motion to approve it.
I'll make a motion to approve.
Second.
We have a motion and a second to approve the name change. All in favor say aye.
Aye.
Motion carries.
Thank you. Next on your iPads, and this starts on page, let me see, I believe 9. This is the Hair Academy, and it's a change in location. Miss Tina Strong Freeman is on the call in order to answer any questions you might have. The school went through a change of ownership and presented all of their documents in March of 2023. However, since then, they've restructured the floor plan that impacts the students, and so the application and updated floor plan has been received, but no other documents really needed to be changed. They're simply changing some of their layout.
I'll abstain from this one.
Okay.
So it's listed as a change of location. Is it in, since it's appears to be just a space change?
Correct.
They're not moving a distance.
That's right. Anytime there's a substantial change to the layout of, especially if it impacts the public, then we need to see the new floor plan. So that's all they're really doing.
Patty, this is your old school, correct?
Right, it's my old.
That I've visited a few times.
Yes,
So it's in the same
it's in the
strip
same
center.
shopping center. Yeah, I've seen it. It looks good, but I'm abstaining.
Just change of location in that same center. Do we have a motion?
I'll make a motion to approve.
I second.
We have a motion properly seconded to approve the change in location. All in favor say aye.
Aye.
Motion carries.
Thank you. Next members,
Thank
starting
you very much.
Ms. Freeman, is that you, ma'am?
Yes, ma'am. Yes, ma'am. Thank you.
Thank you and congratulations. You let me know when you're ready to be inspected, okay?
Yes, ma'am. We sure will.
Thank
Thank
you.
you.
Next on your iPad, starting at page 13, this is Confidence College of Cosmetology. This is very similar to change in location. Ms. Courtney Bennett is participating on the call. The school first got licensed in February of 2023. The application, some of the revised documents, and an updated floor plan have been submitted. The school did the same thing, needed to expand and offer more space for the services, but they're still in the same technical space.
What a wonderful problem to have to need more space so quickly.
Absolutely.
I'll make a motion to approve.
We have a motion to approve this change in location. Have a second?
Second.
Ms. Judy had seconded. And any other discussion? All in favor say aye.
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 Motion carries. Congratulations on your change.
Thank you.
Bennett, the same thing. Whenever you're ready, just send me an email, okay? Thank you, ma'am.
Yes, ma'am. Thank you.
Next on your iPads, this starts on page 35. This is Agape Institute of Estheology. It's a new location. Ms. Kim Storms participated, is on the call to answer any questions you have. The school is located in Franklin. This school was approved at the April meeting. Since then, the landlord presented some issues and the school was forced to change their address. And so you are looking at a revised floor plan. That is a significant change from what the board previously saw. None of their documents are changing, but when the school got ready to open, that the landlord made a change on them.
Since there's a landlord change, is it have you moved a significant distance?
No, sir. It's just about one exit over.
5 miles, 10 miles? Nothing significant?
Less than 5.
Okay. Okay. Roxana, if this one is approved, we'll need to set an inspection.
We'll need a board member as well as a field inspector. It was a new school approved in February, so unfortunately she's been delayed because of the actual move to the location. We'll need to send both if that's okay.
Ms. Storm, I do have a question for you. Are you ready for your inspection now? Are you
Yes.
ready now?
Yes, sir, absolutely.
Okay, great. So we won't have to wait a long time on that, Roxana.
Correct.
Do we have a motion?
I second the motion.
Motion and a second to approve. Any other discussion? All in favor say aye.
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 Motion carries.
Thank you and congratulations. Let me know when
Thank
you're ready.
you.
Thank you so
Okay.
much.
Thank you.
Okay,
Bye-bye.
Storms. Next, members, on your iPad, we're on page 38, I believe. This is By the Blade. It is a new cosmetology apprenticeship school. Ms. Tawana Dixon is available to answer any questions you may have. The school is located in Nashville. This application was approved at the April meeting, pending some updates to the documents. Since then, Ms. Dixon has decided to change the school from an aesthetics school to a cosmetology apprenticeship school. Therefore, you have before you some revised documents, and everything was received timely, so it is kind of changed the way what she's going to be offering.
Ms. Dixon, can you briefly tell us a little bit about your changes and what your school is going to be now?
Good morning. I decided to change to the cosmetology program by me being in the industry of cosmetology for 26 years. I decided to be able to give all that I could offer instead of just being a specialty.
Okay. So you're going to the full cosmetology curriculum, or are you only going to do cos? Are you going to do
Yes.
aesthetics, nails, instructors?
I would like to.
This is just, her application is just for an apprentice school?
That is correct.
Okay, so she will be offering the theory hours at her school and then placing the students in cosmetology licensed salons for their additional 750 hours?
The 750 will be at the school. The other 750 have to be under a supervising professional with 10 years or more. That is correct, yes. So her layout is strictly theory rooms.
Ms. Dixon, I had a note here regarding your enrollment agreement. I'm not sure that we've got a really good, effective date for the enrollment dates and hours of the students listed here. I know that in most of the packages that I see today, we do have certainly the school's hours of operations, things like that, but in this particular one, I don't recall seeing that you have a specific schedule for the individual student, such as they're going to be, you may have full-time or part-time, but are they scheduled to be there from 8 to 4 or as a part-time, some other iteration of that? I don't see that in the contract, in the enrollment agreement. Could you point that out to me?
I thought it's on page 2 under educational information. Number of weeks completed, hours contracted, schedule Monday through Friday, 3:30 to 9:30 p.m.
Okay, so that's the only schedule you're going to have, 3:30 to 9:30 p.m. And everybody will
starting out.
And that would be everybody full-time or part-time, because
Part-time.
okay, so you won't have any full-time students.
Not starting out.
Okay.
As the program grows, I'm hoping to move to that direction.
Okay, that's that kind of satisfies my curiosity on that. It just didn't quite make sense if you were going to have multiple schedules there. Okay. In your on page 57 of our documents, your practical clock hours, I think you have them listed. It may be a mathematical error, but you have a number that is a little bit different than the math would prove out. In other words,
okay.
There's 21.5 hours instead of 25 hours when you do the math. That is on page 6 of yours, I believe.
Page 16 of yours.
I'm sorry, 16, yes.
You're good.
Didn't see my notes. So 750 hours, of course, is 25 weeks, and then under practicing under supervised professional, 750 hours, and you have it 21.5 hours. So can you explain why there's a difference there?
I'm going to get to the exact page. Is this in the enrollment agreement?
Yes, ma'am. This will be page 16
Okay.
in your documents.
For the 21 weeks, or I have?
Yes, you've got 21.5 weeks for 750
for 5
hours.
weeks.
Mm-hmm.
It is probably an error on the weeks. Adding, I can correct that. Correction of the weeks. 21.5 weeks.
Under the supervising professional, are you anticipating, because you don't have a schedule there for those kind of things? I know that relationship is usually between the school and the professional. Could it be that during that time you may be allowing a longer class day for the student?
I am. I was hoping that once the student was able to go to the supervising professional, they were able to do 8 hours
Okay.
a day.
That's what made sense to me.
Okay.
On page 27 in your documents, 68 for us, there's no place for a signature from any school representative that's required in the enrollment agreement. Okay.
Add that to page 8.
That's page 27 for you.
27. Okay.
There's several of these things I'm going to mention, but just to point out to you and for the members, I don't know that we're going to wait to have you look up everything, but we'll make our notes and let the members talk about these. On page 12 for you, you have a form there that you've indicated is a FERPA form for members who may not know. That's a student's right to privacy. If you want to think of it in terms of medical, it'd be like a HIPAA regulation. You have a form there that you've represented as the FERPA form, and because that's not actually required by our board, I did want to make a note and tell you that that is not the actual form. It misrepresents the federal guidelines on that.
Okay. I can remove that.
On back to your page 16, my note said that you only had the one schedule listed, and so we've already covered that. We'll move on. You have listed in your documents that with your schedules, it's the 1,500 hours, of course, for the program. You have that listed as 50 weeks, and that math would be correct. I'm sorry, it would be 50 weeks. I believe you have 46 and a half weeks. So the math is not going to be correct in your enrollment agreement here on how many weeks if you're using that calculation. Page 79 for our members, and 9 for you. On page 79, if we could take a quick look at the curriculum.
What page is that on our presentation?
I think it's 79 for us.
79.
Okay, thank you.
This is a listing and a breakdown of 1,500 hours. I see that you have so many hours assigned for different factors here, different skill sets, but I don't see the state's curriculum listed correctly. So that document would actually need to mimic what the state has.
I think it's on the next page, our curriculum.
Apprenticeship. There it is. Okay. That takes care of it. Thank you. And I recognize that the others, how you want to break that down, but I had missed that page. Okay.
This is just apprenticeship, so you don't have 50. And then
The student still has to enroll for 1,500 to identify that. If our members could look on page 85. Page number. I found a notation. It's page 15 of her documents. So if I can find it in her in the.
It is 85. You were right.
So in here, I believe you're requiring an additional 80 hours before the board accepts the student's application, and I don't think you can require.
That's if they. Well, I can take that out. I was trying to do something if they are not being able to pass the test. I don't want to require, but I want them to come back if they're having an issue with not passing so that I can help them. I don't know. I can word that differently, but that's the reason I don't have to require it. But if they're having an issue with passing the exam.
Right. I'm not seeing it very readily. Perhaps I have the wrong page written down.
Page 14, go back one, actually page 84. I think that's what you're referring to, under additional hours.
There it is, yes.
Yeah.
Thank you, Roxanne.
You're welcome.
Right, you're requiring 80 hours. Yeah, we can't do that for the
Okay,
state.
I can take that out.
Also, on your page 1887 for us, you indicate that you're going to maintain your records for 6 months. I believe we have a 7-year requirement on that, so that's not going to be correct either. And I believe also on page 17, your 17, 18. We are. You have a statement about documents for any leave of absence over 30 days. Let's see if we can find that one. Can you tell me about that?
Well, I was just wanting to know with the student if they're going to be for a leave of absence for 30 days. Is it for a medical leave, or is it something that will they be returning to school, or they're just leaving? So I kind of wanted some documentation to have a reason of why is there a gap in the hours to show why it's not consistent. But if I don't need that, I could take that out. But I wanted to have that so it wasn't any questions, to why this student didn't have any hours submitted for that particular month.
Actually, what I'm looking for here is item number 7 on this page. It says that your file shall include a copy of, and you have several items listed, and you're saying that you're going to have documentation for any leave of absence over 30 days. What I'm saying to you is any leave of absence for any period of time, you have to have documentation, not just if it's over 30 days. So that would not be correct.
Okay, so take the 30 days out. Okay.
Okay, on that same page, members, she has a statement here, item number 4, near the bottom of the page. If a student withdraws within the first 5 days, the school need not submit the enrollment to the board. That's not be permissible. Any enrollment reported to the board. It didn't happen. Item number 5 on the same page. I believe she's already addressed that about 30 days. I believe. On item number 8 on page 88, page 18 for you, Ms. Dixon, can you explain that one to me? If you're having trouble finding it.
I'm trying to. No, I found it.
Okay. What it appears that you're saying here is a student who has withdrawn or graduated, their files will be kept and locked for future reference until the date the student is accepted by the board for examination. You cannot get rid of records just because a student has matriculated and finished their program, been accepted by the board. Those records still have to be kept for the full 7 years. Okay.
Okay.
Oh, item number 15 on page 89 for our members, and this is page 19 for you. We have a policy regarding rounding, suggesting that you are going to be rounding hours and time for a student to the nearest quarter hours. Rounding is never permitted. The student earns the hours they earn. Okay.
Okay.
I have a question. Page 88, number 10, it says the access to student records must be limited to the agents of the board, instructor, administration, and the school. The students should be able to access their files also at any time that they wish to see.
Absolutely. So that would be missing from that.
What page number is that, and the number for me?
That's on page 18 of your documents. And one more note that I had here is on page 90 of our documents and page 20 for you. Your withdrawal policy suggests that whenever a student does withdraw, that you're going to you'll report that to the board. But as I'm reading this now, it appears to me in my mind that looks more like a termination policy that you're talking about. As opposed to a student withdrawing on their own. So there actually could be different scenarios in that. One, a student could withdraw, or number two, maybe you have terminated. But in either case, that would have to be reported to the board. So.
Okay.
Members, that's
I will add that.
Notes that I had on this. Excuse me, I've got one more, I believe. The reentry cost that is listed further in your documentation is not listed in the enrollment agreement. All costs that a student might be required to pay has to be listed in the enrollment agreement. I did not find any curriculum for any instructor program so you're not going to do the instructor?
Not at this time. But I can add the curriculum for the instructor.
That would be up to you if you're not going to offer that right now. So members, as I go through the last couple of things I've got here on this school, there's a couple of other items that they're listed in different places in her paperwork and in the catalog area, I guess, if you will, those kind of things. but there's certain requirements that have to be in the enrollment agreement, and I'm finding that while mostly the items are in there, and you've heard what we've already talked about, some of these things are not really clear or not specified in the enrollment agreement exactly, such as having the students specific schedule. Are they going to be attending Tuesday, Wednesday, Thursday, Friday, and what hours? I see what her hours of operation are, but that still needs to be something that the student acknowledges of when they're supposed to be there, so the board will always know. Again, all the costs are not included in the enrollment agreement. I did find a couple. Our documents don't contain an acknowledgement that the student has read and received and understands the agreement. There is no plan on how to maintain and keep any full-time or part-time students separate. So if everybody's part-time, I think that would suffice here. But if that schedule ever changes, then that would have to be looked at. He does not have a policy. Excuse me, just a moment. I'll come right back to you, okay? She does not have a policy that indicates how or if she's going to accept transfer hours. That's a requirement. The apprentice program has to have a statement that the program must be completed in 150% of the original scheduled course. And that was also not found. Okay. Are you going to be doing any retraining virtually, or is it all going to be in-house?
I would like to do it all in-house.
Okay, that's fine. I believe that's all the notes I had on this. You had something you wanted to say to us, Ms. Dixon?
I did. On the enrollment agreement, on the very last page, I have the acknowledgement agreement for the students.
Can you tell me what page that is?
But my question for me is page 27. It's the at the top it says receipt of acknowledgement, and it's about right before the signature. I do have that area, but my question is, even though that I have the time for the students, you're saying that I need another area where they're saying this is the time I'm going to come. Even though that's the time that I'm open, you're saying I need to say, like, okay, if they're not able to do 3:30 to 9:30, I only want to do, a certain amount of hours instead of the hours that I'm open. They have to sign out. They have to fill that area out.
Yes, Ms. Dixon, I think you're following my intent there. And I've encountered this several times in the documents that we'll have today, that many times the school is listing correctly their hours of operation, and that's not a substitute for specifically spelling out for the student that Ron Gillihan is scheduled to be here from this hour to this hour, this many days a week. That way they have absolutely certain knowledge of when they're supposed to be there, and the inspector would know when to expect them to be there as well. Okay, so you are understanding that correctly.
Yes.
Okay. Did our other members have a question or concern or anything they want to raise?
I just think it needs to be stated more clearly for the students to understand what they're signing up for. Myself, that's how I feel.
I mean, I appreciate you guys know so much about all of these agreements and all of the details. Do you feel like these changes can be made and then have the board and Roxana's team approve it, or does she need to represent?
think the form, and what I mean by form, we don't dictate what things need to look like and that kind of thing. I think the form and format that I see is understandable. I think a student who's going to enroll needs to be able to have more or less a plain reading understanding that anybody could look at it and say, okay, that makes sense. I think that her forms, for my own personal opinion, are sufficient in that, but I've got, probably 20 or more items that really are either not in the actual enrollment agreement as they should be. It's very difficult when I look at these things. I know you all look at them too, but when I look at them and I know that these things are supposed to be in the enrollment agreement, but I see them listed elsewhere in the documents, I really want to give benefit of the doubt myself and say, well, that's okay. But when we really look at it, the student is signing the enrollment agreement. That's their contract. And that spells out the rights and responsibilities of everybody involved. Catalogs, in my view, my opinion, are that, that's where they're listing their policies and things that come under a little different heading in our regulations. So, we've got a lot of schools on this list today, and we want to be fair to everybody, and we certainly want to treat everybody the same. My research on these, I have seen those similar things very heavily through this group of documents that we've got. We've got several that weren't too confused like that, but there's a lot on most of them. These are things that we frequently see, and we've sufficient time for them to do that. That to your impression.
A lot of these students are just getting out of high school and starting, and they really don't know what they're signing until after they've signed it, and then they want to say, okay, this isn't working for me. But they just need to have a clear understanding of how these will be and everything.
It's real clear. It's real easy. The school owner can go online and look at all the documents. I know that Roxanne and her staff send out documents all the time, and they have that interaction. They're doing their dead level best to submit documents correctly, but if we approve a document that doesn't have all the cost outlined, and then later on a student doesn't have their hours released because maybe they owe some money for something that wasn't spelled out in the contract, school thinks it's okay, and there's a conflict there one or the other. That's a civil matter. The board's not going to get involved in that other than we've approved it. So the question is going to come down, I believe, in what what the board's will is on what is too much for them to make a simple correction, as we've done many, many times, make simple correction and whatnot. So
made a great point, Chairman. If we've got several schools missing the same things, for us to be consistent, as you all know, if there are things that are there in the catalog and we need copied or cleaned up, I don't mind reviewing those, because that's the plus to the recording. I ask the school owners to go back through the recording so that it's not just my notes. I don't mind reviewing those if the board's okay moving those forward. If it's something substantial that is incorrect, then absolutely, before you proceed, you may want it represented out.
Again, we want schools to get opened up, and we want people to get on with their businesses and making their lives. I think that a lot of this can be easily corrected. I think it's a matter of having a little more due diligence and setting up their documents. So I know I'm spending a lot of time on this one, but it really is going to speak to almost everything we're going to do today, and I don't want to take 6 hours for that. There are definitely some deficiencies that I've outlined. If they can get those things sorted out into that enrollment agreement, more or less kind of in the four corners. This is the enrollment agreement. It's very clear what that is versus the enrollment agreement. I don't know. I think that would satisfy me a great deal in my own personal opinion. So.
It's easiest for Roxanne to handle it. I mean, you've got so much.
Oh, with what's, I think I've taken note, but more importantly, I love that Chairman Gillihan goes over each piece. It'll be recorded for Ms. Dixon to be able to follow. If the board is comfortable with me reviewing them, I'm fine with these particular items as they were pointed out.
And then for Roxana to go over everything with them and approve their corrections.
Yeah, I just want to add one more statement, and that was at the very end when she lists other schools who are in her geographic area. I don't know what page that was. It had to do with the teach out. Because the schools that she's listed, I don't believe either of those schools offer the apprentice program. They're traditional full-time programs. I don't know that they would accept the apprentice only hours. I don't know that. I don't know those schools well enough, but I would say that if that's listed, there needs to be an absolute understanding that those students would be able to move those hours.
An apprenticeship for that reason is a little bit tricky, right?
Yes.
Because you may not be at the same exact theory level as other schools, so it becomes a little bit more difficult. Sometimes that teach out just means, or contingency plan, that you're able to use their space and continue teaching in their space if it's, roof damage or leaking pipes, that kind of thing.
Ms.
But yeah,
Dixon, can you tell me what page in your document your contingency is on?
Ron, it's on her page 15, our page 85. My only concern is that, like I said, I would feel more comfortable if she was listing the other schools in the area that also offer the apprentice program. I don't own a school. I'm familiar with both of these schools. I don't know what they will and won't accept. I know every school is completely different, but I don't believe either of the schools that she has listed offer the apprentice program. So I don't know if that's a one-for-one swap.
You have an absolute excellent point here. In many cases, again, I don't want to get too far off base on this one, but if in many cases a school will have a teach-out plan that just basically says, we're going to stand here and provide this until that last student graduates, no matter what. That plan. Give refunds in some sort of configuration. We're going to help place you in a different school. You're absolutely right. Many schools won't accept transfer hours in. Many schools wouldn't give full credit and those kinds of things. So your point is absolutely on point. If the teach out is that we're going to send you to another school, and that's the only option they have other than we're going to provide other outlets, then that would need to be revisited.
I have a question.
Yes, ma'am.
Does it have to be another school by it being an apprenticeship program? Can it just be another location? Since I am just teaching, the theory portion.
Well,
because I have other locations, other buildings but they don't meet the 5-mile radius.
Oh, there's no 5-mile limit. No, there's no 5-mile limit.
Okay.
No, not at all.
Okay, that's a clear understanding. So I do have other locations that are available.
I think that's a good point. I mean, because you're only offering the theory at your school in the classroom, you wouldn't need the full school backup plan. I think my only concern was that by listing these schools and putting those schools in writing, I feel like that's an indication that you have permission from those schools, and I don't know if you do or don't. But yeah, to your point, since you don't need an entire school set up, it might be easier to list alternate locations where you could host your theory classes.
Yes, I have alternate locations. I can change that and include their addresses.
Yeah, I think, my experience, right, as a barbershop owner is just we're finding a lot of our a lot of the folks that we're meeting who are entering schools, there's a big difference between a school that's offering the full program and the schools that are offering the apprentice program. And those are not a one-for-one swap is what we're finding when we're meeting students who are going through one program and think they can take their hours elsewhere. That is more difficult than I think I ever imagined it would be. And so I would just say that out loud and on the record.
Yes. Thank you.
We do have a motion on the floor. Monica, let me restate that if I think I understand you. You're moving to approve with the changes that we have outlined. Approval that Mr. Marion.
Correct.
Have a second.
I would second that. If Roxana and her team can approve these changes on the paperwork, I would feel comfortable moving forward. If they can't, I would say it needs to be brought for a represent.
We have a motion and a second to approve. All in favor say aye.
Aye.
Opposed say no. Motion carries. Congratulations, Ms. Dixon. You're going to be approved, at which point you have sufficiently made these corrections to your program. And then Ms. Roxana will set the
Thank you.
customary inspections.
And the inspection would be a field inspector only because it's apprenticeship. Thank you, Ms. Dixon. Just send me the items when you're finished with all of them, okay?
Okay, thank you.
Thank you. Thank you, board members. Next on your iPads, we have Halo School of Cosmetology. The school starts on page 116. This is a new cosmetology school. Ms. Heather Lee Mabel is participating virtually to answer any questions you have. This school is located in Morristown. You have the application, floor plan, enrollment agreement, catalog, and contingency plan, and all were received timely.
Hi, guys. I'm also here. It's Faith. I'm the director and administrative for the school as well. So I just wanted to introduce myself.
Thank you, Faith. And you and your mom are both on the call?
Yes, ma'am.
Wonderful. Welcome. I'll turn it over to you,
Thank
Chairman
you.
Gillian. Mm-hmm.
Thank you, and we appreciate you participating today.
We are excited to be here.
We'll start off. This list is not very long on this, and I think you had a really well put together package for the most part. I would ask you, what is the square footage of your facility?
Our facility is 3,000 square feet.
Okay. Are you going to be planning on doing any virtual classes?
No, not at this time. It's full in person.
On our page 123 members and your page number 4, this will go back to the previous discussion as well. In your enrollment agreement, you did not have a specific time and schedule for the individual student to attend. Did you sufficiently hear our discussion on that previously, or do I need to elaborate?
Oh, no, I did. Let me provide some pages with our schedule. On page 2, 10, 11, and 12, it states that you'll be full-time Monday through Friday, 8 to 4:30.
I see where it says school hours, but you said page 4 is where it's listed?
Page 2.
Page 2, I'm sorry.
Under, yes. And then let me flip to hours of operations too, really quickly. And then we also have hours of operation on page 8. So this is the school hours. This kind of just states when the facility is open. And then those previous pages, page 2, is when the students will be in school.
And that is a full-time schedule, correct? You do not have any part-time schedules?
Right, just full-time.
So,
and then also on page 8, where our hours of operation are, is also our facility square footage, by the way. I just wanted to add that in there.
I do see what you've alluded to here. Again, I think that a student is probably not going to recognize that as their individual requirement. I think I'd still rather see a statement that says Ms. Bennett's schedule on Tuesday, Wednesday, Thursday, Friday, Saturday is X. Okay.
Okay, let me see. Let me take a look on page 2 here. Okay, are you talking about for the student schedule?
Yes.
On page 2, where it says you'll be at school Monday through Friday at 4:30.
And that's in the first sentence.
Yes.
Okay. You know, that seems to be okay, but again, when you look at this page further, you're going to notice that there is no place for an initial or a date on this, so that you can acknowledge all that.
Okay, let's see. So page 9, under tracking students' hours, it says, I understand I must be at school Monday through Friday, 8 to 4:30, and that's where they can also sign. On that same page is our acknowledgement agreement. So this also explains that they have read the contract to its entirety and they have received the contract.
And that's the same schedule you'd have for manicure or anything else? And the instructor?
Yep, our schedules are the same.
Okay. All right, I see that. You do, within the enrollment agreement, I see that you've got signatures and dates, and signatures and lines on just about everything, but on page 2, you are missing that. We're going to go ahead and move on.
Just for the course tuition, I didn't think we needed the signature just because it kind of goes over everything, but I do see where we would need that, so I will add that on there. Anything in that enrollment agreement. Members, page 129, we're referring to curriculum hours for cause. I think you have listed in here that that's going to be 1,500 hours, 40 hours a week, and you have that listed as 45 weeks. I believe if you do the math, that's going to come out to be about 37 weeks. Oh, okay. Excluding the Saturdays and Sunday.
The same question was going to be with the manicure on page 11 and the instructor on page 12. So your math is off just a bit on those.
Okay.
We want to take a look at our page 134, and I'll give you your page in just a minute. Our page 134, and
it's your continuity plan.
The teach out.
Faith? Yeah, the teach out.
Mm-hmm.
Okay. Let me flip over there. Okay.
Just a moment. I've answered my own question here on my page for that. I found the information I was looking for.
Okay.
You don't have any statement in your policies that full-time and part-time students' files will be kept and maintained separately.
Okay.
And again, you're not doing an apprenticeship. Is that correct?
Right. Yes. Yes, I did it. We did put the full-time students, but coming to what you had just said, just keeping their files. We did put like their student hours and, keeping track of that, but I can add that in there. I know it was 7 years keeping that on file and everything, so I can add that on there.
Thank you very much, members. That was the end of my notes on that one. That was very brief. So.
You're not offering aesthetics either, are you?
Not at the moment. We actually are just doing the cosmetology and the nail technician and instructor's course. But, in the far future, we do want to offer the aesthetic, course.
Hard for me to say too. Okay.
No, I just wanted to make a motion to approve her application with the changes that you've suggested.
This would be a new school, so we would need a inspection with a board member.
Correct. Yes, please, sir.
We are ready for an inspection today, too.
You're ready?
You can come on out right now.
Okay, so we have a motion and a second. Is there any other discussion? To approve, all in favor say aye.
Aye.
Opposed say no. Motion carries.
Thank you so much.
Congratulations and good luck.
Thank you.
Thank you.
Faith, when you've updated everything, just send those to me on one email and we'll proceed with the inspection. Thank you and congratulations.
Sounds good. Thank you so much.
Thank you. Board members, we're moving on to our next school, which is Vibe Barber College. And that starts on page 135 of your iPads. This is a new cosmetology school. Mr. Kendrick Jefferson is participating to answer your questions. This school is located in Memphis. The school has been licensed as a barber school since 2003. You have the application, floor plan, enrollment agreement, catalog, and contingency plan that were all received timely. Chairman Gillihan, I'll turn it over to you, sir.
Do we have him on the phone with us as well?
I believe so. Can you hear us, Mr. Jefferson?
Mr. Jefferson, can you hear us? You may be on mute.
I don't see his initials, so we can proceed. If we have any questions, obviously by him not participating, we can delay it till August. But I'll turn it over to you.
Thank you very much. On this application, on page 139, page 1 for him, but I'll just give our pages in this instance. On 139 for us, there's a reference to a student must complete the program in 143% of the originally scheduled time. That typically is 150% as a maximum, so I don't think that there's anything wrong with having a shorter time as his own school policy. You can increase that, I think, a bit.
Amy? Yes, thank you.
Sorry. Too many lights.
Yes.
This is Vibe Barber College. They are applying for a cosmetology school.
Correct.
Okay. Sorry, I was confused there for a second. Okay. Thank you.
On my notes, that was just a question I had for him. I'm sure that was an easy thing to explain, but I did want to mention it. Same page 139. Again, there is no statement in the enrollment agreement that student is supposed to be scheduled to be here from this time to that time, and that applies, as we've said a couple of times already, to different schedules they could be on. So that's missing from the process. page 140, this application does not have a statement to maintain their student files, their full-time versus part-time separately. That is a requirement, and that was across the board in every application we've had today. Nobody had that. I did have several questions about his hybrid virtual programs, so I'm not sure how to proceed with that. On page 164, he is listing an additional charge for students who are in the virtual training program versus the on-site or traditional. That amount of money is listed in the catalog information and the policy information, but it is definitely not included in the enrollment agreement where it would need to be. This particular school did not have any method listed as a backup method for measuring and maintaining their time clock systems. That is a requirement as well. He also did not have listed a transfer student policy. What I've seen in most of these applications is that they will have some statement that reflects the word transfer hours or this, that, and the other, but they don't have a policy to say that we're going to accept this many hours or not accept these many hours or these circumstances, so that policy is not present. So those were the notes I had on this one. If a representative was available for us, I do have lots of questions about their virtual program. I'm not comfortable personally, in my opinion, accepting this without having fleshed that out a bit, because we do have a lot of misperceptions out there. The minor changes that were listed otherwise were pretty easy to correct in the path we've been on this morning. But I think for myself, I wouldn't be comfortable without discussing that virtual. So this may need to be a represent, or you could approve it.
I'll make a motion to represent in August.
I second that motion.
We have a motion, a second, to represent at the August meeting. Is there any other discussion?
Yeah, we want to clarify the represent is to ensure that someone is present with this school to answer our questions.
Correct.
Since no one is present today.
Correct. And the corrections that need to be made, I think, would need to be a part of that as well.
And I did find the transfer policy, but that's just one of the things you mentioned on page 154 at the bottom. But the hybrid is, I think, a new approach for his barber school as well. So, okay.
So we have a motion and a second to represent. All in favor say aye.
Aye.
Opposed say no. Motion carries.
These two going to be combined in the same location?
Yes. The floor plan is splitting the layout for the cosmetology practical hours and the barber, but it's the same building. It's a pretty big building. Thank you, board members. We will continue then. The next school starts on your iPads on page 177. This is Bloom School of Aesthetics, and it is a new aesthetics school. Miss Melissa Hendrick is participating to answer any questions that you have. The school is located in Lenoir City. You have the application, floor plan, enrollment agreement, catalog, and contingency plan before you. I'll turn it over to you, Chairman Gillahan.
Thank you, Roxana. Ms. Hendrick, are you on the line?
I am. Thank you.
Thank you. Can you tell us just briefly a little bit about your school, please?
Yes, we are a traditional 750-hour specialty school of aesthetics, focusing on preparing individuals for a successful career as an esthetician. And we're looking really forward to bringing this opportunity to our small town.
Great. If your application is approved, are you ready for an inspection relatively soon?
I think within about 3 weeks, possibly sooner if necessary.
Okay, great. Glad to hear that. There's a couple of small things that I discovered in your application. I believe starting on page 181 for our members. Let me get over there myself. I'm looking at the document that appears to be your student application, and you have some basic information on there. I'm sure you can see that. You have part-time and full-time programs listed and so forth. I'm not really, I see that you have, again, your daily hours of operation, 8:30 to 5:30. But as with all the other schools so far today, that component that specifically lists, this student is scheduled to be here during these hours, because you do mention full-time and part-time, I think, as well. So that statement would be missing. Refund policy, again, appears to apply only to a teach-out enclosure scenario. I don't think I located any other refund policy on how you intend to manage that should a refund come necessary if somebody just withdrew from school. The requirement also requires that would go out within at least 45 days. Okay.
Yes, to address those things, in addition to operating hours, I can add student hours. And then as far as the refund policy, I did state in the enrollment agreement that refunds would only be provided if we were no longer able to operate. It states that they're not required, of course, to pay for any hours that they don't accumulate. But as far as a true refund, it would really only be if Bloom School of Aesthetics was not able to continue to provide the service.
Can you tell me where that is in your documents, please?
Page 184 of our
yes,
pages.
184?
Yes.
Okay.
Page 3 of hers.
Thank you.
You're welcome.
And I do have the refunds within 45 days as the final sentence there. And while I have, I was also going to let you know that since the time that my paperwork was submitted to you, I have reached out to Tennessee School of Beauty to be more assured that I do have a teach-out plan. I spoke with their representative of enrollment, Bobby Powell, and she has agreed that they would participate in that.
Okay. As with all the other schools this morning, I believe I did not see in your policies anywhere your method for backing up and having a backup method for your student hours, and how you would track the difference between full-time and part-time and keep those records separately. They have to be maintained separate for the inspector. I do see your refund policy.
Okay, good. As far as time tracking, I plan to use UAttend app as well as a paper backup. UAttend does allow you to, the instructor only, not students, of course, but to be able to manually update hours if, for whatever reason the app is down or a student fails to clock in, then we do have that backup paper method. And if they're not able to log in, they're to notify the instructor as soon as possible so that the hours are tracked accurately. As far as a separate tracking method for part-time versus full-time, can you still use the same app for part-time and full-time and the paper backup? And okay, yes. So I would continue to use the same method, but of course, just carefully tracking each student's hours, knowing their expected schedule, and making sure that everything seems accurate with their documents and mine as well.
Right. They just need to be separate from one or the other for the inspector's purposes, I believe.
Okay. Yeah.
I've got a quick question for you. On your page 1, backing up just a little bit, that document page is identified as a student application, and it has that basic information I already mentioned. Your enrollment agreement, the document titled your enrollment agreement, starts on the next page. It's listed as page 1 of 6 for you. Are you intending for those to be 2 separate documents because of the way they're labeled? You have an application and an enrollment agreement?
Yes, sir. I had those as 2 separate documents.
Okay, so I was reading that correctly. So in that case, we do have a little bit more issues with this because the enrollment agreement needs to specifically have all of those student information issues, such as name, age, education. Okay, so all those factors that are listed, and it's more than I've just mentioned, as well as their schedules, their dates of attendance, all those things. That personal information needs to be included under that heading of enrollment agreement as well. Okay, so those are 2 separate things. Okay.
Okay.
Now, before I move on with this one to the rest of the members, can you explain to me your virtual program here? Are you doing virtual training?
Yes, I have a total of 8 hours per week as part of the virtual hybrid portion of our program, and that's to help to accommodate working adults, parents, and people that want to reach their career goals but can't be in class Monday through Friday. That's been me plenty of times in my career. So I do plan to have my hands, directly in what they're doing in their time away from school. We're going to have ways to measure that they are participating outside of the classroom, and that will be either through testing on assigned readings, presentations, projects. So kind of a tangible way to ensure that they are, actually utilizing their time and not wasting time and, just being consistent with what we expect of them.
Ms. Hendrick, let me make sure I'm really kind of understanding. The real question I have for you, I guess, is this going to be a synchronous program or an asynchronous program? Are they going to be actively participating in an ongoing live class, or are you anticipating that they're going to be logging in and doing their work on their own?
It will be asynchronous because, again, I want to try to tailor to their schedule to be able to, if they need to do their 4 hours at, 3 to 7.
That's what I thought I was understanding. The board typically has not approved any asynchronous programs. Any type of virtual training would need to be in a live format, with the student being directly supervised at all times, in other words, participating with you. So I think a Zoom class or something like that, Teams with video, those kind of things.
Okay.
So anything that they were doing on their own, the board I don't believe, would be able to approve that. So
okay.
Is that something you'd be willing to remove from this?
Yes. I could do live Zoom classes. Are you able to do any, pre-recorded options as well, or no?
It would have to be live, synchronous, with personnel attending. I mean, with your staff supervising or being engaged with them. So it has to be It can't be something they can just log in and do on their own without having your staff there. So if they want to log in at 3 o'clock in the morning and you've got somebody scheduled for that, then that would be just fine if you're sitting there and you're on Zoom with them, and I'm just using that platform because it's easy to remember.
Sure.
There's many. Asynchronous would not be appropriate. So
I will change that to synchronous to move forward.
Members, that is the notes that I had on this school. Everything else, except for that, just a couple of little things aside from the virtual, is a pretty clean program.
And I'll make a motion to approve with the changes.
Second.
We have a motion and a second to approve with those changes. Would that include the inspection, Patty? Yes. With the customary inspections? Any other discussion? All in favor say aye.
Aye.
Opposed say no. Motion carries.
Thank you.
Congratulations. If you can get those changes back to Miss Roxana and take care of that virtual program, then I wish you lots of luck.
I appreciate you. Thank you.
Thank you, board members. Our next school is starting with page 191 of your iPads. This is DAY College of Cosmetology. They are opening a new cosmetology branch school. Miss Amanda Young is participating on the call to answer your questions. This school is located in Paris. Miss Young has had a licensed school in Jackson since 2018. You have before you the application, floor plan, enrollment agreement, catalog, and contingency plan. Oh, hey.
I'm here.
You're here. Welcome.
Hey.
Okay.
Thank you.
Miss Young,
Hi, how are you?
welcome. Thank you for coming in. And we do so many of these on the phone now. It's nice to see some
I
faces.
was like, I want to be there. It's just something about being here. It just means a little bit more.
If you don't mind, I'll give you just a brief couple of minutes to tell us a little bit about your school and your program.
So we opened a school in Jackson, Tennessee, May 2018. And so we've done really good. We've had 130 students graduate successfully, and we're doing really good there. And we just wanted to branch out another school in Paris, Tennessee, because we had several students driving from Paris. And we was like, well, that would be a good, location for us, since we already have current students that are driving that far. And then we're offering the aesthetics program there, which they don't offer. So we thought that would be a good incentive.
Sounds great. I hope things will continue to be well for you folks. I know you've heard a lot of the comments we've made on previous schools, so you may have a couple of these in here. Hopefully not too many. Is your school, your existing school is accredited, correct?
Not accredited.
Okay. All right. Mm-hmm. You had a reference to the Department of Ed on page 215 for our members, and I don't recall that. So
not accredited.
I want to take a look at that. Okay. It was wrong idea. On page 203 for our members 7 and 8 for her documents. Start and end dates for the students and their schedule, as you've heard me say for everybody else. I did not notice that in your documents, and everybody has their hours of operation, but that statement on the students is missing. Tell me a little bit about your sanitation policy here. I see that you do have sanitation items for the students to do, but I think that the question really is, are you requiring them to do state required things as part of their training and being able to work in the workforce, as opposed to setting people up to be janitors in the school?
Gotcha. Yeah, we usually do our sanitation from 4 to 4:30, and we really stress the EPA pre-sanitize, all the sanitation requirements. They're assigned, each student is assigned the sanitation at the end of the day, and they put their name beside each job, chore, whatever.
For our members, sometimes I know if you're not working in these schools a lot, there's occasionally issues with sanitation. There have been legal cases in other states where students have been required to basically be the janitors in the school outside the bounds of being trained in how to take care of these things for their licensure. So in your documents, I think you probably want to clarify that just a little bit. Okay. You have an evening schedule?
Tuesday and Thursday we meet on campus from 5 to 8, and then we do like online, virtual Wednesday and Friday.
My note says that your full-time and part-time schedules are not really clearly defined. That will be on our page 198.
On my page,
you do have full-time hours, and you have the number of weeks and months there. I see that. And I guess what I'm looking at here is in your part-time, the full-time seems clear, but in your part-time you have 18 to 20 hours. So how would a student or how would an inspector know whether that student was supposed to be there 18 hours or 20 hours or 19?
The part-time students, I have class begins at 9, followed by a 15-minute break at 10. Part-time students are allowed 18 to 20 hours a week, and I have it tomorrow. And
this is at the very top of the page, under just above your cancellation policy on page 3 of your documents.
Okay. I just need to add that in there.
Well, you have 18 to 20 hours. So is it 18 hours or is it 20 hours or?
Well, on my attendance policy on page 6, I have it in there. It's kind of says specifically like full-time students Tuesday through Friday, 8:30 to 4:30. Part-time student hours are Tuesday through Friday, 8:30 to 1:30. Do I just need to add that into that other little section maybe?
I think you need to be specific on whether it's 18 hours or 20 hours.
Okay.
Otherwise, people won't know. If you were into a position where you were charging overtime charges because they're attending at 18 when you think they should be there at 20, then that's going to bring up questions.
Gotcha. Okay.
I have a kind of a general note here. I'm going to come right back to it in just a minute. I did not find your grounds for termination. Oh, I'm sorry. I'm looking right at it right now. I apologize. Same page. That's good. What is your system for backing up your hours?
And we have a paper copy that we keep up with also. Then they clock in with Praxi. They scan their badges, and then we print their hours.
I think that needs to be stated in your documents is what I'm saying. Also, are you having an apprenticeship program?
We are.
Okay. So I did not see the required statement that all apprentices must be complete within 150% of their original contracted time. Also, keeping your full-time and part-time student hours, student records separately would need to be added. Okay. Those were the documentation notes that I had, and except this one. And my note is that you have quite a bit of information that is contained in the general information that is not located in the enrollment agreement. And you may have heard me mention earlier that there are certain items that must be within the enrollment agreement. Based on my note, there were several items in there, too many to kind of go into and just give you a list. What I'm going to suggest on this is depending on the board's outcome. I believe you would need to revisit that and strictly go down the state's requirements and list and put the items. A lot of them may be throughout your documents, but the things that are listed in the state requirements need to be within that enrollment agreement portion, not just the entirety of the catalog. Having said that, now we need to talk about your virtual program. Okay, tell me about it.
We do classes Tuesday and Thursday. They're on campus from 5 to 8. They do like the first hour is theory, and then they start working on their practical. And then they do Wednesday and Friday. We do some VS Zoom classes, and then we do they upload their documents, take pictures, videos, that type of thing.
So all of the time that they're receiving credit for is done in a synchronous way, in a live format, correct?
Right.
Okay, so nothing, they're logging in at 2 in the morning and submitting things that nobody's supervising.
Yes.
Okay. And how are you tracking their hours for that?
We have a same proxy. We use the same thing. We take their documents and we compare to what they have, and then we approve their hours to.
Members, those were my notes, and it sounds like this is a synchronous program. There were several changes here, but out of the items that I've outlined, notwithstanding the items being scattered throughout the documents, the others were fairly straightforward and simple changes. So, motion.
I'll make the motion to approve.
I'll second that.
Have a motion to approve with the changes outlined once they're approved with the customary inspections. And you said you're ready to start now to get.
I'll say within a couple of weeks.
Couple of weeks. Okay.
Exactly.
And if it's okay with the
finishing
board,
touches.
given that the school has already another branch, then we would just do a field inspector inspection. Is that okay? Okay, thank you.
But this is a new school altogether.
New branch, yes.
I don't know if I can volunteer myself to drive to Paris, so I've got to be careful what to say here.
And I think when
no offense, I love Paris.
Not many have done the branch, but when they do, the fact that they've been open already. So she's had a school since 2018. I think we can send the field inspector and no board member. If it's okay with
and then
you.
when I'm in Paris, I can swing by and say hi.
There you go.
Okay, we have a motion and a second with the necessary changes, corrections. All in favor say aye.
Aye.
Opposed say no. Motion carries. Congratulations and good luck. Thank you for coming in.
Thank you so much. Thank you, board members. We will move on. Our next school starts on page 216. This is Black Girl Beauty School of Careers. This is a new cosmetology apprenticeship school. Miss Amanda Manigault is participating on the call. This school is located in Chattanooga. The request was originally presented to the board at the April meeting. The application with a change in the business name and revisions to the enrollment agreement and catalog were received timely. So there's a minor change to the name and some new documents for you to review. I'll turn it over to you, Chairman.
Thank you for participating with us today.
Thank you.
Roxanna, who do we have with us? Is it Ms. Galt?
Yes.
Okay.
Miss Amanda Manigold is on the phone. I heard her voice.
Okay.
And again, this is strictly apprenticeship. It's a new cosmetology apprenticeship school.
Can you tell us a little bit about your apprenticeship program, please?
Yes, we are an apprenticeship-only school with over 45 years of experience in cosmetology. The students, excuse me, learning experience and placement opportunities are enhanced through the studies that provide a balance of 50%, which is distance learning theory, and 50% on-the-job training. And we provide opportunities in cosmetology, manicuring, esthetician, natural hairstylist, and instructor programs that are designed to prepare students for direct entry into the job market.
Thank you very much. I'm looking at your documents. I believe it's page 2. It's 222 for our members. You have a chart, and I see the beginning and ending of the contracts and so forth. But you have a chart that outlines the different programs you're going to have. Under the clock hours, for instance, in the cosmetology, you have your 1,500-hour program, but you have 42 to 50 hours per week. Can you explain to me the difference between 42 and 50 hours, how you're arriving at that?
Yes. Basically, the board, you can get up to 50 hours. And so they'll do the first 750 hours with the theory through distance learning. And then when they go to on the job, they can get anywhere between 35 and 50 hours a week rather than just getting 35 hours like they would get during the theory.
Okay, so during theory,
So
which is, I see you have full-time listed. You have theory as, full-time is 35 hours. So you're considering that 35 hours is a week is just theory portion for that apprenticeship. Am I reading that right?
That's correct.
Okay. So then when they're out into the field in that portion, you're just allowing that they will have the ability to work more hours than 35.
Yes.
Okay. All right. Now that makes sense. Okay. I did not see in your documents your statement on the apprentice program that they must be completed within 150% of the maximum time frame. Can you tell me where that might be?
Yes, I believe that's on page 2 in the enrollment agreement and on page 28 in the catalog.
Okay, I do see that. Thank you so much.
Mm-hmm.
Thank you. Members, if you would, can I ask you to go back to page 222 of our documents? If you look down at the very bottom of the page, not to make too much out of this today, but just so this helps you understand, see on the very last line it says student's personal schedule. Something as simple as that is what I've been talking about with when they're actually supposed to be there. So the student knows it's supposed to be that way. Okay. And thank you for having that in there, Ms. Galt.
Oh, you're welcome. Thank you.
On 226 in our documents, I believe you have a reference to a minimum of 10 hours per week for this program.
What page is that in my
Page 6.
Page 6, yes.
Okay, yes. Students on apprenticeship are required to work a minimum of 10 hours a week once all hours are completed, if and when the student is choosing to continue on the apprenticeship learning pathway until life. That's if they have completed their hours, but they have not went to take their state exam yet. They haven't actually got licensed yet. And so if they want to continue to stay in the salon, they can do that as long as they at least do 10 hours per week. They can remain on the apprenticeship program until they're licensed.
I don't believe that's going to be permissible under our regulations here. Once a student has completed the required minimum hours for the state's purposes, then I don't believe they could be obligated to attend any other portion. So I think that
okay, I can remember.
Problem.
Okay.
Would I be correct on that, Roxana?
Yes, and I want to make sure, Ms. Manigault, so the 50%, which is, we'll stick to cosmetology to keep it simple, that has to be done at the school, whether hybrid using Zoom or in person, but those hours, then when they finish that 50%, they must take the theory exam and they must pass it before they go to a shop under a supervising professional with 10 years or more. That is the remainder 750 hours. But if once they finish those hours, they cannot continue at the shop. Their apprenticeship at that point in time ends. That doesn't mean they have to test, right? You wouldn't force them to test, but their hours are done.
Right. Okay. I can take that out. I can remove that.
Thank you.
Right. Could you point me in the direction of your termination policies, please? Two 31. Oh, thank you very much. I believe on our page 255, I believe I'm looking at the right page on my notes. I have a note that there's apparently some additional costs listed here. Well, I'm sorry, it's page 255. There's a table, a chart that identifies a series of different fees or charges that could be charged to the student. While this is in the appears to be in the catalog or general information portion, all of that information would need to be within the corners of the actual enrollment agreement itself. Okay.
Okay, you said this is in the catalog?
This is on, this is your page 20. You have a table there, a chart. All that information would need to be within the enrollment agreement.
Okay. Yes, I thought that was in there. Okay, I'll move that over.
And
yeah, I didn't realize.
Again, as with all the other schools today, you do not have a plan listed in your policies of keeping your full and part-time students separate. Okay.
I do. Oh, in the enrollment agreement.
That policy can be elsewhere in the document, but you do need the policy that you're going to keep them separate.
Okay, well, I won't have any part-time students. All my students will be full-time.
Okay.
And I believe I do have that in there.
Okay. You did have full-time. I just didn't see I didn't see a policy regarding either one, but if you're only going to have full-time, that makes sense. And you may have just answered me a minute ago. Were you planning on doing any type of virtual classes?
All my classes are, I'm an apprenticeship only, so we will just do the distance learning online, and then they'll go to the on-the-job training in the salon for the second portion. Our courses are synchronous, so they'll be online with an instructor, during the class time from 8 to 5.
That was the end of my notes on this school. Questions?
No, I would just make a motion that we approve this pending the changes that you've requested.
We have a motion and a second to approve with the necessary changes. Are you ready for an inspection?
Yes, thank you so much. And yes, I'm ready for an inspection. Well, I have a couple meetings this week, so I will be ready as of Monday of next week.
Okay.
And I think because this is a apprentice, it would just be a field inspector.
Correct. It'll be just a field inspector. And Ms. Manigault, if you'll send me just on one email all of your revisions when you are done, then we'll be able to coordinate the inspection.
Thank you guys so much. I appreciate it.
Hold on, we haven't had our vote yet. Okay. You've heard the motion in a second. All in favor say aye.
Aye.
Opposed say no. Motion carries. Congratulations and good luck.
Thank you so much.
Thank you, ma'am. Thank you, board members. We have one more school, and this is on your iPad, starting with page 286. The school is Nisha School of Cosmetology. It is a new cosmetology school. Ms. Tanisha Noble-Weir is participating on the call. The school is located in Memphis. You have the application, floor plan, enrollment agreement, catalog, and contingency plan for your review. I'll turn it over to you, Chairman Gillihan.
Thank you, Roxana. Ms. Ware, thank you for joining us. Can you tell us?
Thank you, sir. Thank you so much.
Can you tell us briefly just a little bit about your school, please?
Yes, sir. We are a full cosmetology school. We are located in Mendenhall Road. We're 2,600 square feet, 1,600 square feet clinic floor. And, sir, we want to bring the school to the area. And also, I was interested in having a school because when I went to cosmetology school, I didn't learn a lot. I was thinking they could have taught more. And a lot of students are leaving school uneducated. So I just want to bring something back to the community.
That's great. I appreciate you trying to make these efforts for us. I'm going to go down a short list, and there's probably no need to really respond to most of these yet until I kind of get to the end. There's just a few things, and then if we have some questions, we'll ask you. So let's see. You're going to have full-time and part-time, correct?
Yes, sir.
Full cosmetology program?
Yes, sir.
So you'll be doing aesthetics, instructor, manicures, everything?
Yes, sir.
Okay. So members, I'm sorry, are you planning on trying to do anything virtual?
Not at this time, sir.
Okay, great, great. Members, our page 292, and it's starting, I guess, on her page 1. There's going to be a discrepancy between the hours and the weeks. We've seen that a few times. Sometimes their math is just off a bit, but sometimes it ties into kind of odd schedules with hours that are between this many hours and a minimum maximum numbers for each week. So they need to be pinned down when that's the case. Can you tell me about your crossover program?
Yes, sir. Just With the crossover program, give me just a minute, sir, please. Okay, here we go. We will be accepted students coming from other schools, and the curriculum will be followed by the State Board of Cosmetology and Barber. 1,500 hours of training are required for applicants for a certification of registration as of Master Barber with
Yes,
less
ma'am.
than 1 hour of
I'm
schooling.
sorry, excuse me. Yeah, we can read that. You're identifying crossover curriculum, I believe. When you're offering the crossover program, there should be some curriculum listed on what specifically you're going to be covering. That's a 300-hour program.
Okay, we'll just be, yes, sir. We'll just be covering crossover for cosmetology. So if they have a barber's license, they can do a crossover to cosmetology,
Right.
which will be 300 hours.
Right. So what are you going to be teaching during that 300 hours? And where would I find that in your documents?
Sorry, sir. I guess I forgot to edit it in the document. I'll fix it.
Okay. Right. We don't have anything in there that says what you're going to be teaching in that program. So
We'll be teaching the cosmetology curriculum.
on page 302 for our document, my note refers to the weeks versus hours. The math is not adding up correctly between her normal full-time and part-time schedule, so the weeks are not quite matching the hours. In other words, a full-time student attending 30 hours a week is going to be finished in 50 weeks, not 75. 75 may be their maximum time frame, so that can be understandable, but it's not really clear. It's very confusing the way she has it. I'm not seeing the actual curriculum listed for the COS program, the aesthetics, the instructor, or the crossover. She has a statement on page 311 saying that the state board requires that the students wear black scrubs. The state board does not have a regulation that dictates exactly that. A uniform may be required, but we don't dictate what that is, so can't put words in the board's mouth.
I'm sorry, sir. That was a misunderstanding.
Okay, that's okay. It happens.
I'll fix it.
Vaughn, could I ask you to take a look at page 308 of ours, her 16, to see if that curriculum is okay with the breakdown? She's elaborated a little bit from what's in the statute, but I think it copies and pastes what's
308.
in the 308 is our page, yeah. Mm-hmm. It's coming from our rules, but
she does have
okay.
She does have it for the COS program here, and I understand that sometimes they'll break it down into
right
a little bit smaller segments. But I did not see the same information for aesthetics or any of the others.
Okay, could I ask you this, sir? What if I was to drop the aesthetic program?
I'm sorry, I didn't hear you.
Yes, sir. I was just asking, what if I was supposed to drop? Could I drop the aesthetic program of the curriculum?
Whatever you decide
and just do the Cosmo.
That would be your decision. Yes. Basically, the cosmetology covers all the disciplines, but you don't have to have the standalone. But that's your business decision.
Yeah, exactly.
Yeah, not ours.
Yes.
Members,
I think I'll do that.
If you'll look on page 309, this may help everybody here. On 309 at the top, she talks about the instructor program, and she lists 1,500 hours, and then she also lists 300 at the same time, side by side. That's required. The instructor hours are 300 hours. but if you look down, we you wouldn't know, are you doing 1,500 or 300 hours in that. She does have, I believe, 100 hours in lesson planning and motivation based on textbook and practice teaching, 200 hours. That's not what the state curriculum is. That could simply be copied and pasted from the state's website. And you're going to find the same type of lack of that information for any of the programs other than the COS, which is on the previous pages. So I wanted to point that out.
Okay.
I believe the tuition schedule is a little bit off from the other documents you have. Let me take this. You have listed on our page 314, but you have listed in your documents that your 2023 completion licensure rates are in there. So I don't believe you could have any completion or licensure placement rates to be listed. So you'd have none to report. You have
yes, sir. Sorry, I'll fix it. I guess it's just typing so fast.
Sometimes copy and paste, we'll get a little carried away there. I've got a few other notes here that I'm just going to kind of paraphrase and keep them pretty brief. You've got a 2-page enrollment agreement. Frankly, it's very confusing. It's very discombobulated. That's my word. It's very difficult to read and understand. In addition, it does not contain many of the elements within those 4 corners, so to speak, that are required as part of the actual enrollment agreement. Some of your cost is not indicated in there, transfer hours. You don't have a cost associated with any of those kind of things. Members, this is one that I really struggled with as I was reviewing, because some of the information is scattered throughout some of the documentation, some of it is not. The condition of the enrollment agreement in this one gives me great concern. I don't believe, in my opinion, that this enrollment agreement is sufficiently inclusive of required information. So, I'm going to pause on that one and ask if you folks have any questions or concerns or anything you'd like to have explained.
Just as a general comment, Ron, I'm noticing as we go through these, especially because we have so many today, that the simple applications with fewer pages where everything is laid out are almost easier for us to review and approve than some of these that have 30, 40 pages. And that gets into where the errors or the numbers aren't the same on multiple pages, things like that. Just a comment, an observation, I suppose, from today. But I can see where this is. If this were printed today and I was to sign it, I'm not sure I would understand it either.
Thank you, Amy.
Complicated for this.
The size of the school's documentation, you're right. Sometimes it gets a little cumbersome. And I applaud everybody for wanting to be very thorough and inclusive and get as much information in there as they can. And that's, more information is normally better. I want to be clear, I'm not making assessments or judgments in my research with these based on anything other than, am I seeing the right criteria according to the rules in the right places and the right locations? And when I see conflicts, particularly in things like the minimum number of hours required, maximum number of hours required. If you're scheduled for 30 hours, it's simple math. That comes out to a weekly equation and a certain number of weeks. And there are certainly factors that can adjust that, a leave of absence, for instance, and some things like that. But I'm looking at the actual technical parts of it with the checklist and the rules. And I think the board has been very generous today on allowing some changes and things that are repairable. I think this particular one, in my opinion, is beyond that. I think this one at least would need to be a represent, in my view. I would suggest, depending on the board's actions here today, if this were not to be passed, I would suggest that the applicant would go back to the drawing board, research the state's rules, and create a document that actually puts the right information in the right locations. That's the only way that the public can be protected when they're signing these documents, is to have everything clearly outlined and where it should be. Okay. So,
I'll make that motion.
we have a motion to have this applicant represent or to deny. Okay. We have a second. Any other discussion? All in favor say aye.
Aye.
Opposed say no. Motion carries. I'm sorry to inform you that your application has been denied. You may represent it once these necessary changes and corrections and items are satisfactory. Okay.
Yes, sir. Thank you.
Thank you, Ms. Ware. Thank you, board members. That is our last school. We still have two more appearing before the board, and we'll move on then to the legal report. Please let me know if anyone needs a break. But until I hear from you, we will continue. If you will turn to your iPads on page 334, I believe. Yes, we have two continuing education seminar requests. The first one before you is Cheers to the Careers That Choose Us, and you might not have any questions for either of these. These are our standard courses that we have to present. You've got information there. This one is from Mr. Thomas James. He is here in person. These dates that he's requested are September the 10th and 11th, December 3rd and 4th, and then he is requesting a date for February 4th and 5th of 2024, which is not a bad idea because we rarely have them at the beginning of the year. So I'll let you review those, and his courses are all virtual.
Hello, Thomas, and welcome back today. It's good to see you again.
Hey. Hello, everyone, again.
Eliminate December. Mr. James, you want to tell us about your program just a little bit? Got anything you want to say?
Yeah, I'm just wasn't necessarily planning on doing classes this year, so sorry about putting in the request so late. But I was just the requests to do so. I also gave a lot of courses possible. I am working on 2 future projects, so I was just wanting to see if the topics that I gave were okay, so that my information would not get in the way of me creating these 2 projects of mine.
I've sat in some of your classes. They've always been good.
Thank you.
I believe I may have been in your very first class, wasn't I?
Yes, sir. Yeah. You put me on the right path. Thank you.
We have a motion to accept this application for continuing ed.
Second that.
We have a second. Do you have any questions or any discussion?
Yes, sir. I do. I have one. I am working on a software for asynchronous learning. How far in advance before a meeting would you guys like to see it?
For asynchronous?
Yes, sir.
Members can't see anything ahead of the meeting. You mean how far in advance should you get it
Would
to
you
me?
like it? Yes, ma'am. Mm-hmm.
I need everything a month in advance.
At least a month?
That's
Okay.
with everything.
Yeah.
We have a motion and a second to approve this class. Thomas, I've got a question.
Yes, sir.
Whenever you take your role, this is your class. You're not working with somebody else on this one.
On this one, no, sir. It'll be
your class. Mm-hmm. Okay. What kind of time frame do you intend to have on getting out certificates, things like that? Is it automatic now, or do you, whenever they complete the program at the end of the session, do you just email them to them or the board? Or what?
Getting the certificates to them, I try to tell them, give me about 24 to 48 hours, but I get it out before that. It's just because the format is there, but then putting everybody's name that was actually in attendance for the entire time, because almost always there's at least one person with technical issues, so I hold off.
Just so the rest of you know, I asked Thomas this because not reflecting on him, I think it's something we need to ask all of the folks with these programs. I've had some phone calls that found their way to me occasionally with different programs where they're not getting their certificates in a timely manner, and it's created some issues for some people down the road. Full disclosure, Mr. James used to work with me, and I will be abstaining on this vote. But he does an excellent program, and I was confident that he had a system for doing that. But I think going forward, we need to be aware we probably need to query folks on how quickly they intend to get those things out, because it can cause problems.
The concern is they're not being sent out?
They're not being sent out. Sometimes I get phone calls. I'm sure the board gets information that I can't get this provider to certify my attendance, because obviously if they're running close to the expiration of their license, they need those continuing ed hours before they. Thank you for that, Thomas. Got a motion and a second to approve. All in favor say aye.
Aye.
I will abstain. Motion carries.
Thank you, sir.
Thanks, Thomas.
Board members, on page 341, this is also an addition to our approved continuing education sessions for our instructors. This is making of a master, KINCC Education Group. Ms. Kimberly Anderson, I believe, is on the call. This particular session is a little bit different. If you see on her page, she's got 2 to 4 hours of virtual learning, Saturday, Sunday through Monday. I have some questions on how my team is going to be able to structure that and track it, as long as instructors are given 16 hours and we don't get that reported information until then we can do this. Otherwise, for us, it becomes very difficult. We probably have 15 sessions right now taking place each year. There's roughly 1,100 educators. So if we think about it, that's less than 600 a year. So we have a lot of courses, which is wonderful. But it does make it difficult on the team, just like it's made it difficult on you all. We don't have board members attending anymore because there's just too many. It makes it difficult on even my time to attend. But we're doing the best that we can. So I'll turn it over to you, Chairman, for any questions you have.
Is there a date?
There is not.
I just make a motion.
Good morning.
Morning, Ms. Anderson.
Is there a date for your course? Good morning. Sorry, manners.
Good morning. No, there is not a date that has been set, and there is a reason for that. First of all, one of the things I'm currently doing, this is my 5th year doing CEU and providing CEU for the state of Tennessee. Based on our surveys and some of the feedback that I've even heard from some of the board meetings, we are in a position where some of our educators, through the teaching methodologies, are looking for more extensive information to cater to their disciplines, as well as the in-person learning is not really there. The attendance is not as great as it was because so many of us are virtual. But also in the virtual space, although virtual is convenient, sometimes the 8 hours can be long and extensive, considering, what is going on there. So the purpose of this is to create a avenue and a platform for educators to get information, not only teaching methodologies, but also able to have information within their respective discipline, and be able to use that in their classrooms. So that's why there is not a date, an official date set upon approval. My request is I can either submit a date 60 to 120 days out from the scheduled class, or there's no date, and as a vendor, I would schedule those classes on the as-needed basis.
Definitely don't think that I'd be comfortable approving without a date certain having been set.
So the classes would, and I understand that, which is fine. The classes will not only be virtual, but some can be in person as well. What I'm trying to do as a provider, and for those of you that have attended my classes know that I'm extremely passionate about continued education. I feel like the beauty industry starts with the instructor, and that is my core focus and has been almost for the last 10 years, even attending CEUs myself as a almost 20-year industry instructor. But one of the things that I'm trying to do, because so many times, and I'm saying this based on me attending a class as well as the feedback, I have, went above and beyond trying to make sure that my teaching methodologies don't just focus on COS, because of course COS is the number one discipline as far as the number count for instructors, but I try to make those classes conducive to include all of the disciplines. And so what I'm trying to do long term is create those exclusive classes for these disciplines. So not only will they get teaching methodologies, a lot of our instructors that are currently in the classroom are not working behind the chair, behind the table. They're not working in the classroom, so they're not as focused on those trends and new developments in the beauty industry. So these classes are more catered toward that, to address those issues where, as the industry is constantly evolving, constantly changing, the educator has, they have a master toolbox to utilize the information and the subject matter that is specific to them. So not only will we teach those teaching methodologies, but we'll give them the tools they need to teach it to their students.
Thank you so much. Amy, I think you're concerned about the schedule or your dates is absolutely valid. I'm a little concerned about having these spread out over so many days and such disparate hours and times and such as that. I'm not sure that
I don't feel comfortable approving anything without a date.
Yep.
Because we have 15 scheduled and we have so many on the calendar, I don't know how I approve anything without knowing exactly when this is going to happen. My opinion.
Do we have a motion?
I'll make a motion that you represent when you've got a date scheduled.
Okay. Can I ask a couple of questions then as I'm getting my dates together? Because actually putting together a date is no problem.
Very briefly now, we have a motion regarding the date. I want to make sure that I'm clear as well. I don't think I'm very comfortable in having so many short, broken up attendances here. I think I would still prefer to see the 8-hour days so that people can actually better project and schedule when they're going to get complete with this.
I mean, I kind of love the 4 hour. I mean, we've been to the 8-hour sessions. They are some long days. And if you're trying to do this maybe after work, but I think, yes, a clear understanding of what days and what hours for us to review. Yeah.
And how they're going to track them for Roxana and stuff.
Yeah.
Yeah, I like the shorter classes too.
So we have a motion and a second to have a represent on this. Any other discussion? All in favor say aye.
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 Motion carries.
Thank you, board members. Thank you, Ms. Anderson. We are going to skip and move on to the legal report unless the members need to take a break. We'll get Mike up here. Oh, you're here. Thank you. Members, on your iPads, you'll need to press the button and switch over to the legal report, which is 76 cases. Let me know if any of you aren't able to do the switch, and I will turn it over to Mr. Underhill. Thank you.
Good morning.
Hello. Good to see you.
Good to see you. I know the board needs a little bit of time to review, so I'll just stay quiet unless you have a question.
Mike, it's been just a minute since I looked at these last week. Did I see a represent or some follow-ups on the back of this?
There are 3 represents at the end, cases 74, 75, and 76. And then we also have 8 barber cases and, I guess doing the math, 65.
Sounds like the barbers are doing okay. Case number 24, if I'm reading that, that's regarding a school inspection.
That is correct.
We take a look at number 38, Mike. That's, again, another complaint about a school.
As you can see, that coincides with case number 36.
39 associated with that as well. Okay, separate. Forty-one was from the Attorney General, so that was, is that an administrative complaint or? Okay.
They do kind of have their own department.
Was that?
No, it's an unlicensed case. I just wanted to make note.
I did not.
Number 33 was the second offense for unlicensed individuals. There were 4. Roxanna, are we still, since this will be the second instance, are we still moving forward with license revocation with the third offense?
That's still our process, yes.
Okay. Thank you.
Thank you.
Or unlicensed in that shop. Mike, in that case in 33, that penalty, is that to the shop? Is that to the manager? Is that to the individuals?
That's to the shop. 33 is to the shop, and then 34 is to the manager.
Okay. On the last one, 76, will the board be finished with that one at this point with the recommendation? Oh, I'm sorry, I read further, never mind.
So what we're doing, and Roxanne and I have had a lot of discussion about this, and Roxanne and I with some third parties have had some discussions with what we're trying to do. Move it from one file box to another file box. As you can see from that lengthy description, and the board is obviously very familiar with this case since the board requested that this person that was temporarily suspended provide medical records, and here we are 2.5 years later. Hindsight being 2020, I probably should have put a time limit on that, and I think going forward, if that situation occurs, I will request a time limit. But we're no further along after 2.5 years, so I think the way the facts are and the way this thing is postured, I think by moving it over to the do not renew list, because he's up for renewal at the end of July, I think that gives us a chance to maybe find out where he is. I can't find him anymore. So I think since there's no litigation to monitor, I think it probably, in hindsight, would be more appropriate to move it to do not renew. in its current state. So that may be more of a housekeeping thing, but I think it's probably more appropriate based on the way the facts have laid out over the last 2.5 years.
Or board members, if I can kind of explain a little bit how that works. Automatically, our renewal notices go out to individuals with plenty of time to renew, shops, individuals, and schools. So in this particular case, since we've not been able to locate them to handle the suspension the board members decided, before this individual can renew, they will have to reach us because that automatic process is what's on hold. So it's not that we're taking away the right to renew per se, but it would make them have to reach us so that we can then be in compliance with the complaint. Does that help?
It's not just an automatic mail it out when you submit it.
Correct. Correct.
You got to give us a call.
Yeah, so that we can take care of this and properly protect the public, right? That's why the suspension on this case was there.
And Chairman Gilligan, as you know, towards the end, there's obviously another step that I'd like to pursue procedurally, if I can get the adequate information through the do not renew.
Do we have any other questions? We need a motion to accept the legal report.
I'll make a motion to accept the legal report. Second that motion.
Motion is second. All in favor? Aye.
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 Motion carries. Mike, thank you. Excellent job.
Thank
Appreciate
you, Mike.
very much.
Excellent. Thank you, board members. We are going to come back to our full presentation document, and now we are on to our applications to test. Give me a minute. Thank you. And we are starting on page 349. We do not have any felony applicants at this time, and those would be the individuals incarcerated that needed to sign some type of an agreed order. However, the board members have given me the authority to complete these agreed orders for anyone that is outside of a facility and needs to start working to provide for their families. Those individuals go ahead and get an agreed order for the 2-year probationary period. We have such a person here. Ms. Renisha Flowers has already received her consent order, has signed it and returned it, and has been approved for license. So she is technically working. I just need a motion to make this official on the record.
That motion.
Motion and second to make this official. All in favor say aye.
Aye.
Motion carries.
Thank you. We do not have any reciprocity applicants, which is always nice to know that we're able to move everyone so quickly thanks to the board members understanding and setting all those parameters. It's something we always enjoy. So next on your presentation is our miscellaneous items, and we will start with page, make sure I get you right, 355. This first item is a request to waive the need to retest pursuant to Rule 0440-01-.10, which states that an applicant must apply for and receive their first original license within 6 months of passing the examinations. The board may, for good cause, waive or extend this time frame. The board has given me the authority to extend an additional 6 months. So today you have 2 applicants before you that have gone past a year. The first one before you is Ms. McKinley Elise Brown. She's provided an explanation of her delay requesting the initial license. She passed her practical aesthetics exam on November 16th, 2021. And we would need a motion to proceed. Otherwise, she'd need to retest.
Make a motion to proceed with her licensing.
I'll second that.
We have a motion and a second to allow her to proceed. Any discussion? All in favor say aye.
Aye.
Motion carries.
Thank you. The next is similar. It's the same rule for cosmetology, 0440-01-.10. Applicant must apply for their first license within 6 months of passing the examination. In this particular case, she also went past the year. This extension request is coming from Ms. Kirsten Parkinson. She's provided an explanation that she was completing high school after she'd actually completed her natural hairstyling hours. She finished her practical natural hairstyling exam and passed it on December 20th of 2021. So we would need a motion to accept hers as well.
Make a motion to accept her license.
We have a motion and a second. All in favor say aye.
Aye.
Motion carries.
Thank you. Board members, next before you, we have a little bit of a unique situation. We have probably 2 more coming in the pipeline, so we want to be able to look at this example and see how we proceed maybe with a few others. This is a request to take the Tennessee examinations. This is pursuant to Tennessee statute, Tennessee Code Annotated 62-4-110A, where a person who desires a cosmetology license shall have 1,500 hours. That same statute lists, of course, aesthetics, manicuring, and natural hair. Ms. Lisha Kalitska moved here to Tennessee from the Ukraine. She is in the process of obtaining her social security number. She's in the process of getting her immigration documents as well. She, of course, wants to start providing for her family soon. So she's provided her educational documents that she brought with her, which reflect starting her education as well as her work experience in 2005 all the way through 2020. Obviously, coming from the Ukraine, they're under a very unique situation. They don't have all the documents that we can normally ask for or expect them to bring with them. Ms. Kalitska is asking for us to accept the certificates you have before you as proof of her education and experience over a decade, and allow her the opportunity to test.
I make a motion that we approve her to take both exams.
I second that.
We have a motion and a second for both exams. Any discussion? All in favor say aye.
Aye.
Motion carries.
Thank you, board members. That is helpful because I do believe we have 2 more that are going to be similar to this, and will follow the same information as long as we can see a length of work experience as well. And then, the language may or may not become an issue now that we have PSI with a broader network of exams in other states that are virtual. So that is the hope, that if they need the exam in Russian or another language, they can have access to that. So I appreciate that. On your iPads, we have, this is really just a presentation of a business model that we want to put on her license file. Ms. Keisha Griffin is presenting her information with TKE Beauty Academy. She is a licensed cosmetology instructor, and of course, as such, instructors have to teach in a licensed school only. Her target audience here are licensed professionals who want to advance their training. We've presented a few of these in the past. If you recall, one had written a book for the exams. Several have advanced courses, but because they are licensed instructors not teaching in a school, I think it's good for them to present something that's in their file in case a complaint's filed against them. And generally, we've presented it to the board for you to review and simply, acknowledge that this can be part of their license file. We can have a motion or not. It's very much informative so that they get to present what they're planning on doing to us. Oh, she is on the call. Okay, I did not realize. So if you have any questions, I'm
here. Yes, ma'am.
Thank you, Ms. Griffith.
Members, do we have any questions regarding this? I think it's very clear that she's not giving any credit hours to anybody, so then there's no expectation from the for recognition from the state in that manner. Motion?
Need a motion?
Presentation?
I think what we've done is referred to the board meeting and that the board members were informed and put that letter in the file. So if it's okay with you, we'll do the same thing. Just prepare a letter saying that we've presented her.
Okay, so we'll make a motion that we've received this.
Perfect.
And approved.
Sounds good.
I'll second that.
We have a motion and a second. All in favor say aye.
Aye.
Motion carries. Thomas James who's just here, wrote a book.
Oh, okay.
He did.
Thank you all. I appreciate it.
Thank you.
Good luck.
Good luck.
Thank you. Thank you. All right.
Thank you. Board members, you've got, this is informational, of course. The director's report starts on page 370. Bless you. These numbers are through April 2023. We have a fiscal year. We have added $6,733 to our annual amount. We are a very lean machine. That's okay. The reserve is at $1,306,354. Obviously, at the August meeting, hopefully we'll have some preliminary numbers through June. Fiscal year ends at the end of June 30th, and then we have some entries at the end. But you know, anytime you want additional information, just let me know. But that is just to share with you where we are. And if the members are good proceeding, we will move over to new business unless you want to take a break. Besides new business, we'll have a sunshine presentation at the end if any members need to leave.
We'll need to leave it.
At noon? Okay. So let's get through then this, because we will need you probably here, Ron, and then we'll proceed. I'm going to turn it over to our attorney, Hugh Cross, who's waited patiently to capture the legislative piece and then talk about the draft rules you have. Thank you. Hugh.
If it's still morning, I'm going to see if I can get through this with I've got a cough or something going on, so I have a mountain of cough drops, but I think I can make it. I don't need a vote on anything, so if something comes up or anyone needs to leave, I mean, feel free to leave. Most of this will be pretty fast, I think, but the sunshine presentation is about 45 slides, so I'll make it as painless as possible, I hope, but that may take a few minutes to get through. Do we need a break, or are we just going to push through?
I think we'll push through it if,
Okay.
because we've got two board members that need to leave, but I think the sunshine presentation can be done without quorum. So we'll get through this for sure.
Yep.
Thank you.
All right. For legislative updates, the main thing I have here is Public Chapter 214. That's the eyelash specialist bill that everyone's aware of at this point. I'll discuss the draft rules here momentarily. The other public chapter is the educational equivalency language bill, and this bill I decided to present mainly because it's replacing the terms GED and HiSET with this new language, high school equivalency credential. So HiSET, GED, both of those terms are listed in the rules and the statutes for Barber and Cosmo. So I came across it drafting the eyelash specialist bill because I figured it might be a good time to go ahead and address that language change and the educational piece too under the rules. So we'll see that in the draft rules. But those are the only two legislative updates I have. Moving the rules, the equipment waiver rule, I'm still working with the Attorney General's office. I had to resubmit. There were some changes that were requested on our side. I actually requested them, but they needed to be done, and it's causing a more delay than I hoped, but it needed to be done. So they're still reviewing them at the Attorney General's office, but they should be good to go. I'll let you know. And then in terms of the eyelash specialist rules, you should have a red line. If you want to pull that up, we can go through that. And
It starts on page 378 on your iPads. Thank you.
And this is really to get board input. So I'm going to take down, Roxana can help me as well. We're going to take down as much commentary and notes as necessary, and then I'll go ahead and make the final changes and see if there are any other changes internally that we need to make, and then present at the next board meeting for vote, which means the rulemaking hearing would be at the October meeting, not at the next one, at the August one.
And board members, if you are not signed up to get notified with emails after this meeting, at some point visit the website, and under I think when we do board member orientation, we talk about that. Make sure under the contact us, you sign up to get notified. We did a blast on Public Chapter 214 a few weeks ago. So a lot of our schools, thank goodness, and instructors are signed up. They started calling us immediately, wanting to know about the eyelash, license, and it's an individual new license. 300 hours, both exams, pretty much falls in line with all our other licenses. And then the specialty shop, an eyelash shop, that's also going to fall in line, similar to an aesthetic shops or a natural hair specific to just eyelashes. And so the draft rules that Hugh has put together cover that, as well as the high school equivalency while we're there. I think that's a great thing. And this is it, yes. So Hugh thinks, and he's maybe being optimistic, which is good, that at the August meeting, we'll tweak any suggestions that you all have from here, and then possibly in October be ready for full rulemaking hearing. So PSI already has it. I mean, so this public chapter goes into effect July 1st. John and I have been working on it a lot. We know we're ready to go. So come July 1st, PSI has the theory and practical exam. We will be using what they have for Texas and incorporating our rules and laws. And so we're going to use the same statistics of theory questions versus laws and rules that we do for the natural hairstyling, because they're 300-hour programs. So they line up as far as number of questions. That seemed right. So that exam will probably be ready to launch at the end of August. If you think about 300 hours being needed and we don't start till July 1st, I think that's the soonest we'll need it. Internally, we've already started the process to create, we call it a transaction, right? A specific request online, so our students will be able to do that. And after today's meeting, depending on the guidance you give us, we're going to add the public chapter to the landing page of the website so people can all see it. And we're also going to do a blast that's ready. Hugh has helped me draft it to all of our schools. The TCAT schools and the private schools will get the information. And so as the statute, the law passed or the public chapter passed, cosmetology schools and aesthetic schools will be able to teach the 300 hours because those are both under 62-4. And they obviously now teach it under the discipline for aesthetics and cosmetology. I think Hugh did a terrific job pointing back to the statute on the curriculum so we don't have to reinvent it because the law actually breaks it down. And then the schools as the experts would be able to elaborate more. They already have all the knowledge for sanitation and what have you. So, any questions you have or want to kind of toss out. I've been tracking the calls and emails that have been coming in. Interestingly enough, the majority have been, I'm a cosmetologist. Can I still do this? Can I be grandfathered? What am I going to need to take? Which, of course, they don't need to take or do anything special because they're already able to provide eyelash services. And so with that's a smooth transition. There's nothing for those individuals that can already offer the services. This is that person specifically looking for eyelashes. You're going to need to be on a mic so I can hear you. Thank you, Patricia.
They'll be able to do a mobile shop also with eyelashes like they do.
If they wish to, and they can now, right?
Okay.
Right now, we've
So
got
things
one or
like
two
that.
shops that just do makeup. These would be just eyelashes.
Somebody had asked me that. Okay, thank you.
Absolutely.
I know there's going to be an amazing.
You told me that. I was devastated.
There's two, right?
And so one of the interesting questions, since I want to value our time and not lose two of our members that have come up, and Hugh and I have talked about it, John and I have debated it, is regarding the school. A specialty eyelash school seems like not necessarily the path since we have cosmetology and aesthetics that can both do that, but it's something to think about. But the law isn't written in a way that the schools is open, the shops are, and the individuals. However, I've gotten several calls from the shops that specialize in eyelashes that have been doing this now for years and are really good at it. And so their question is, can we also teach? And it's a decent question, but obviously they don't report hours. They're not licensed to do that. They're not necessarily preparing for the exam. So a thought I have that I'm happy to share so that if we don't draft it today, at least for the next meeting, you ponder on how we could add it to these draft rules is, could an apprenticeship program for the eyelash work? Because this law adds it to the apprenticeship program. So they would be doing 150 in the school, take the theory and pass, and then the practical hours under a supervising professional who would have to be a cosmetologist or an esthetician. But what about these specialty shops? If these specialty shops that offer and have offered eyelash, that's their line of business, could they, under the rule structure, we mentioned them and they proved to us that they have specialized in eyelashes, could they take on?
How long?
Well, for the 150 hours, right? So no more than 2 months.
I mean, for how long have they? Do they have to
That's for you to decide. I think that's
right now it's 10 years, right, for barbers.
Right.
And
all supervising professionals are 10 years. So maybe if we include the shops as expert shops offering those services, maybe they'd have to be open 10 years. That may be a bit much. The whole trend, I think, really took off 5-7 years ago, maybe 10. But when it did, and it became the thing to get, some of these shops really focused on that and sell the product, right? They have different exemptions. Something to think about, because that is one of the questions that I'm getting that is a really good question that if we did something, it would probably have to fall into these rules?
I guess I'll just tell you what I did, a summary of that, and then we can go from there. But the bill, it's pretty clear. It's similar to the hair braiding bill structure. It kind of spells out a lot of what needs to be in the license and the curriculum. So I just added the definition for eyelash specialist on the Cosmo side, eyelash services shop, added the fee, $60 fee, added the high school equivalency credential language per public chapter 114 that I mentioned a minute ago. Added the language for the education piece, the 2 years of high school. I changed that a little bit. It's really a preference, but I just took it out of the bullet points and made it a paragraph and then citing to the statute instead of it. My hope is that if they, if the language changes again with high set or GED or high school equivalency, if that language changes, then my hope would be that the rules would just direct to the statute, because that's what would be changed, and that way we don't have to go through rulemaking again just to change the language. But that's all I did on the Cosmo side. I didn't touch the apprenticeship piece. So this eyelash specialist public chapter requires, as Roxana said, 50% of the hours, the 300 hours, to be allowed through apprenticeship. But that's already in the statute and in the rules. So on the statute side, it's on 624120J, and on the rule side, it's on 0440-01-.036. So it's already in both the statute and the rule, so I didn't touch it. It could be added again in a different place, but I don't think it needs to, because the eyelash specialist just should be governed by the existing apprenticeship statute and rule. That's sort of our take on the legal side, anyway. And then the barber side, the only thing I added there was the high school equivalency piece. That's it. If you don't have any changes, that's okay. I'll represent these again at the next meeting once I get more internal insight, and we're going to see if potentially some other rule changes can move with this set as well, so we're not just doing constant sets of rulemaking. But yes, sir.
If you are a licensed cosmetologist or a licensed esthetician, you would also be able to work in an eyelash specialty shop, or you could have the 300-hour license being just an eyelash specialist. Okay.
The statutory definition for cosmetologist or esthetician wasn't changed.
Okay.
So those are still the same. So there's no reason that
So if Frank has an esthetician shop license, he can hire these eyelash specialists as well to perform these
Just eyelashes.
Just eyelashes. Okay.
I was being a little. If you were to see a crossover in that direction,
Barber
from barber
Okay.
to be able to accept to be able to do the eyelashes, because that barber can pick up the
And
cost,
they definitely can.
and it would just be added into that kind of curriculum for that.
They wouldn't need to do anything. Master barbers right now can do eyelashes, so they really
true.
don't need anything else. Just like cosmetologists. The issue would be, because this is under 62-4, which is the law under cosmetology, would be the teaching, right? So I don't think the barber schools, without some type of change, could teach it.
Right.
But otherwise, barbers
They can still do it.
absolutely can. Yes.
Okay.
I would have a little challenge with lightening the amount of years you would need to have an apprentice under it, just because it's a newer craft.
If we did a shop, you mean, or?
No, if we allowed it to for the teaching, I think it should meet the same criteria. I don't think just because barbering or cosmetology is an older craft
Right.
is why, if anything, I would flip it. But I think keeping it the same congruency like
Absolutely.
everything else is just makes common sense to. We're not trying to figure out 19 different things, right? So, I mean, and I know we don't have to do that now, but it's just since we.
Yeah, the law says must be licensed 10 years. Supervising professional must have 10 years. So, and this, we're not touching, I think that law dictates and falls for eyelashes as well. The thing to consider for you all, maybe as just homework, so we can see if we can do anything, would be so your apprentice student that just does the eyelashes would go to a supervising professional who would right now have to be a cosmetologist or an esthetician with 10 years. That is pretty clear. But what about these shops that have had maybe maybe what you're saying is have to have been specializing in offering eyelash services for 10 years? Would they be able to take on a student instead of being supervising individual professional? It would be a business supervising the student. And maybe they have the 10 years.
I think it's going to depend on what the definition of they were an eyelash place, right? Because if they were doing them, they're going to tell you they were an eyelash place. So what's going to differ somebody that was doing it in a kind of diluted fashion and somebody that was truly an expert? I think it becomes gray there as well. So I'd rather us lean towards being overprotective than wishing we pulled back.
Sanitation and.
Yeah, just the whole thing. Yeah, I mean, I'd just rather have an expert doing it than somebody who might qualify because their licensure does it, and then they can justify, well, I do my Aunt Mary every year for the last 10 years, but that is not going to put her in a position to be a true expert.
In that case, we leave it alone because right now that's how it would work. It wouldn't involve the shops at all. It would be the supervising professional.
There's one next to one of my business locations. All they do is eyelashes. Those shops currently are licensed as cosmetology shops.
Probably skincare shops.
As skincare shops, and then they can hire cosmetologists or estheticians.
Yeah, absolutely. But your skincare shop doesn't do hair. They just
right.
Do
they don't do hair.
Right, exactly. But that's most likely what they have right now.
Who governs the skincare shop licensure?
We do.
Oh, okay. So just on the skincare.
We have a manicure standalone shop, skincare alone, natural hairstyling alone, and now an eyelash standalone shop.
Gotcha.
Yeah.
See all the options, Frank?
Shave shop only, no haircuts. Shave shop.
I think Hugh did a great job with the rules. They're simple. They refer back to the law. If the board doesn't have any changes, these will move forward internally for us, and we look at them in August to see if we can proceed.
Thank you.
I think August is going to be our time on this. I'm sitting here thinking back to our very first rulemaking hearing that most of these members participated in that went about 16 hours.
17, right?
Oh, God. Okay, so if we're good, and I know, Ron, you need to leave at noon, and Miss Anita needs to leave as well. You can leave whenever you're ready. I think for the presentation, we'll turn it over to, we've got it here on the projector as long as you can see it. If you're good with us proceeding, members, we can keep going.
Sunshine Law?
Yes, Sunshine.
Okay. Will I need to come and do this online or anything? Or
No. And you've seen it. Both
Yes,
you and
I would
Anita
have.
have been members for a while. This is, we haven't done it in a while, so the other members, we'll be watching. It's kind of lengthy, but I'll turn it over to Hugh.
Members, thank you all for your hard work today. I appreciate it. I'm going to head out.
Absolutely.
Right.
Thank you so much for everything,
Bye-bye.
Ron. Thank you.
Thank you.
It's all yours, Hugh.
All right. You are my sunshine. So this presentation is about the sunshine laws. Open records, open meetings. I'm going to read this entire. I'm just kidding. So this disclaimer is basically just saying that this is not, if you have questions about the public meeting, open records, any of that stuff, just contact your board attorney. But it's if there's third-party questions, anything like that, just send them to the board attorney so that they're not thinking they're getting legal advice or that the board members are giving legal advice, that sort of thing. But that's about it. We can move to the next slide. All right, Open Records Act That's TCA section 10.7.503. As you can see here, it goes over the definition of an open record. Now, this slide does kind of go between board or commission. So just if you see commission, just pretend that it says board or board member. Public records or state records include documents, so papers, letters, maps, and books, media, photographs, microfilms, films, sound recordings, electronic data processing files, and output. Other materials, regardless of physical form or characteristic, as long as it's made or received pursuant to law or ordinance or in connection with the transaction of official business by any governmental entity, TCA 10.7.503. So this one on the right side where it's talking about public records or state records do not include, it just means if you have, for example, if you have an iPad, like today we have the iPads with the documents on there, the documents would be considered public records to some extent. I mean, there's an argument for that, but the iPad itself would not be a public record. So the device, or if it's on a computer like my computer, the documents or the files on the computer, if they're related to government business, can be considered an open record unless an exception applies or a privilege applies, which many do. But the iPad itself will not be subject to open records. Public meetings. What is the Public Meetings Act? This is a statutory definition. The statute says meetings of a government body should be held in the open in order to comply with the intent and spirit of the Sunshine Law. So that's what it is. What is a meeting? So a meeting is governed by a section TCA 844-102B2, and it essentially says convening of a government body that's part of a public body for which quorum is required to make a decision or to deliberate toward a decision on any matter. That would be a meeting. So what is required for a meeting? It's right there. You got to have the notice. That's important. The content, the location, the agenda. Generally, you're doing it for the public. You know, this is an opportunity for the members of the public to come and speak, or if it's applications, that sort of thing. And then minutes need to be recorded, as you all know, because we take the minutes and then the board votes on them at the next meeting. That's pretty simple. What happens if the Public Meetings Act is violated? Essentially, if we were to move forward with, let's say, a rulemaking hearing and proper notice wasn't given, wasn't on the agenda, all of that, it would just be deemed null and void. So we just do it again with proper notice. All right, there's a definition I just gave you. Section 8-44101A, the General Assembly hereby declares it to be the policy of this state that the formation of public policy and decisions is public business and shall not be conducted in secret. So I'll get to the public policy in a minute. It's a couple of slides down. This Section 844-101 is basically just codifying the First Amendment, the state's version of the First Amendment. So free speech, you have to have free speech as well, but that's pretty simple. This one I will try to summarize, but this is basically trying to explain sort of, it's going back to the meetings again. What is a meeting? So if it's not a meeting, it's not governed by the Public Meetings Act. But if it is, then you're subject to scrutiny based on this statute. And it's really if you have two or more members that get together and they're discussing business. So business such as, we need to discuss this at the next meeting. Here's what I think. That's deliberation. But if it's just something like board member has an article they would like to share and say, I would like this on the agenda, that's not deliberating. That's just saying you want something to. That's really all that is. It's just going in. This slide is just going into. You need to be open and accountable for your discussions and make sure that they're done in public. So this is another reiteration of the same definition, but All meetings of any governing body are declared to be public meetings open to the public at all times except as provided by the Constitution. So again, that goes back to the freedom of speech argument that I just discussed in the previous slide. You can move to right governing body. This slide is defining the governing body. It's essentially what I just said. If you have two or more members and they have the authority to make decisions or recommendations on behalf of the board. So if you're going to make a policy or administrative change, such as rulemaking, as a sort of discussion about that. If one board member is talking to another and says, I'd like to discuss this rulemaking change, you just don't really want to go back and forth about it. If you have any questions on that, you can always contact Roxana or I, and we'll certainly go over it in more detail. You can move to the next slide, please. Right, so here's another definition of meeting. This is the same definition I said before. It's basically if you have a public body where you have to have a quorum and they're meeting to discuss or convening to discuss a policy change or administrative change, that would be a meeting. Again, at the little box there, committee, subcommittee meetings, those are also included. Now, there's an exception coming up about an executive session. So if a board member were to discuss an issue that normally would be public business directly with the attorney or the executive director for a specific item, that could be under considered an executive session. So that would not be a meeting. But we'll get to that in a minute as well. This one's interesting. This is another caveat for what's not a meeting, and it's since this board, many boards and commissions don't have inspectors, but this board does, and so it's basically saying that inspectors can't go in and an inspection is not going to be a meeting because they're just going and doing their job. But if the inspectors get there and they start trying to deliberate how to make a decision, that could be considered a meeting. So that, generally our inspectors go out with, they have they have the inspection sheet and they have kind of a checklist to go through. Now there's some discretion there. It's not the same thing as making a decision. And again, it would need to be a policy decision or some sort of administrative rule change. I can't imagine an inspector going in and just changing a rule, just ad hoc. So, but that's what this is saying. You can go to the next slide, please. So this has some case law on it. As you can see, this is about clear as mud. So you have a lot of case law that you have to go through and kind of clear out the gray areas. But chance meeting of two or more members of the public body. Again, as I mentioned before, two members together, if they're discussing something that really should be public business, that could be an issue. But if you just show up together and you see each other and you're talking about things, if it's a chance meeting, it's not going to be considered a meeting. Now, if it's a chance meeting and you start deliberating a policy change or an administrative rule change, that kind of goes into the meeting. So that if you have any issues on that, just stop talking and contact the board attorney or Roxana here, and we'll get you on the path. You can move to the next slide, please. All right, this is another slide on what is not a meeting. This Attorney General opinion is interesting. It's kind of, it goes into detail. It's interesting in the sense that it goes through what's a deliberation, and it's basically what I said before. If you have a policy change, if you're advocating for a policy change or an administrative law change, it needs to be done in the public. And if the board member has questions about a rule or a potential rule change, you can always reach out to the board attorney, and I can kind of walk you through that. If I think anything's needs to be deliberated in public, then I'll let you know. You can go to the next slide, please. All right. It's not a meeting. Lunch break, restroom break, smoke break, recesses between morning and afternoon sessions, and adjournments between days of multi-day meeting. These are all times when board business should not be discussed. So No, that's okay. I mean, it basically goes back to what I said before. If you have two or more members of the board together, it if you're discussing policy or administrative law, it needs to be deliberated in public. The statute allows for regular meetings and special meetings, and these will all be subject to the Public Meetings Act, and the exception would be the executive session, and that's what I mentioned. If a board member has it really needs to be in anticipation of litigation. So if there's some sort of lawsuit pending, or there could be a lawsuit pending, and the board wants to get together with the board attorney or executive director or both, that would most likely be under the executive session privilege. Since I've been here 4 years almost, I've been involved with one executive session. It's not a common thing. I mean, the board would be fully aware that this is going on if there's an issue like that that's happening. So we can move on to the next slide. There we go. All right, so this is just going into the executive session exception again that I just mentioned. I mean, it is important. It's something that if the board is under threat of litigation, we have to tread carefully on how we're going to go about that. I would imagine that Roxanna and I would probably know about it pretty soon if there's any sort of lawsuit that's pending, and if it's necessary, we'll notify the board. That's it. We can move on to the next slide, please. The board may not deliberate about any specific matter before it or potentially before it in any executive session. So, as I mentioned before, executive session, the privilege is sort of narrow. So if you have an issue, you're pending litigation, the board or certain members of the board decide to meet and call an executive session with the board attorney to get legal advice. Start in the executive session and you start talking about other issues that are not related to the litigation. That's not appropriate for an executive session, so that wouldn't be under privilege. So again, if this happens, we will be pretty spot on in terms of holding the executive session properly and making sure that it's narrow and within the constraints or the parameters of what we should be discussing. Anything else, any issues outside of that need to be discussed in public at the board meeting. How far does it go? Okay, this is the Attorney General opinion I was mentioning. I mean, this is interesting. If any of you ever get the courage to go and read this Attorney General's opinion, it goes into depth. It's pretty good. It could last that long, yeah.
A long one.
So this was specific to a county and people applying for jobs, and it's if you're applying for a state job essentially, and you're having discussions with the applicant, that would not be considered. I mean, that wouldn't be public business. That's between the applicant and the potential employer. That's really all that Attorney General opinion goes over, and it's interesting, but it's very limited. So most likely wouldn't be applicable here, but good to note. We can go to the next slide, please. All right, this slide goes back to what I mentioned earlier. This is really about deliberation. So the chair emails someone else on the board, another board member. Here's an article. Please put it on the agenda. I mean, that's not going to be public business. That's just saying, I have a topic of interest. Let's add it to the agenda. We can have discussion. The second piece there would be an issue. So if you have a licensee application, you're considering revocation. If board members are discussing that outside of a public meeting like this, that could be an issue. I mean, that would be deliberation, and that's not something that a board member or the chair can unilaterally decide. The board has to discuss it together, and it needs to be done in public through the Public Meetings Act. That's all that's saying there. And, next slide, please. All right. So this slide is basically saying if you have a question as a board member, please just ask the board attorney before you go making assumptions and and contacting members of the public or contacting other board members. It's really the best way to go. If you have a question about something pending, an application, a rule, a past rule, a statute, anything like that, please just contact the board attorney. I'll just save everybody the trouble there. And next slide, please. All right. This goes back to what I was saying before, the chance meetings. So if you have a chance meeting where 2 or more board members show up and at the same place and they have a discussion, if it's about particular issues, that could be considered a public meeting. But if you're sending a direct email, if the chair sends an email to a board member or a board member to the chair or a board member to another board member, that's not a chance meeting. I mean, that's initiating conversation. So you got to be careful about that. You can go to the next slide, please. All right, so this goes into the in-person quorum. So what do we do if 1 or more members cannot attend a meeting in person? The absent member may participate telephonically, but all votes must be done via roll call vote, and that is so the public may know how each board member voted on a particular issue, which we do that in rulemaking. I mean, you have to have a roll call vote for that, and there's a list on the Form 7037, the Form 7039. There's at the end, the final page or the second to last page, there's a list of all the board members, and it has how they vote. And that's something that the Attorney General's office looks at, the Governor's office looks at. Members of the public may look at it, but it's always there. It's an important piece, and not to scare anybody, but that's what a roll call vote's for. It's just to be clear on who's voting for what. We can move to the next slide, please. All right. What if 1 or more members cannot attend a meeting in person? So there's the statute there, A-44108B1 and 2. So if the members are present in person, make a quorum, then the meeting may proceed as normal with other members participating by phone or electronic means of communication. So if we have quorum, then other members can appear remotely, and if it requires a roll call vote, they're not going to be able to vote. But that's the statute on point there. However, it should be noted there's a policy particular to this department that says any member attending by electronic means of communication does not count towards the quorum. So if we need 8, we need 8 members in person to make the quorum. If we have 8 and then a 9th and 10th member on remotely, that's okay too. But if we need 8 and we have 7 in person and 1 and the 8th one attending electronically, that would not count towards quorum per this department. So this is a interesting case. I didn't know about this one. I had to look this up, and I'm from Shelby County, but it's interesting because it's essentially as you read through these cases for public meetings, they're generally construed most favorably to the public. So it's looking for broad. It has a wide breadth. A lot of the cases are talking about if something is leaning towards the deliberation side, then courts are going to see it as a deliberation, as opposed to the presumption. It's interesting. I mean, a lot of these cases discuss about how wide that breadth can be. Now, you can go through and case by case, and if there's a question on one of our board members whether they're conducting something or having a meeting, there's plenty of room to go in and specify how that was not a deliberation, and the board member should, if that issue is discussed later at the board meeting, it should not be null and void. But again, that's something that would be settled in the court, so we're a long way from that. Just if there's any issues, any questions, just contact your board attorney, which will be me, and we'll go through all of this. You can move to the next slide, please. And here's some more cases. These are all about notice. So you have to, for public meetings, you have to give proper notice to the public so they can attend and comment. However, the comment is not automatically allowed. I mean, it's if the comment is going to be disruptive to the meeting, you can now if it's going to be disruptive to the meeting, or it's going to the board attorney can put a time limit on the discussion. If it goes over the time limit or it's going to be disruptive, it can be cut off. The comment can be cut off. But generally, these cases are saying that citizens have the right to participate in a meeting and observe, but not necessarily communicate or to make statements in the meeting. It doesn't guarantee that they're going to make a statement. I mean, generally, a member of the public would request to be placed on the agenda. The agenda would be given proper notice to other members of the public, and then if there's room or time at the meeting, if a member of the public shows up, they can be allowed to speak within parameters. That's all those cases are saying. And this is a three-pronged test. This goes back to what I mentioned earlier. It's really all about public notice. There's three prongs to it. The first one is the contents of the notice must reasonably describe the purpose of the meeting or the proposed action to be taken. So that would be the agenda. You can move to. There we go. There's number two. All right. So we have the notice, which reasonably describes the contents or the proposed action. That's number one. Two is the notice must be posted at a time sufficiently in advance of the actual meeting. So this is there's a statute on point for this anyway. So it requires that notices be posted 48 hours in advance of the meeting. So this program gives more than the minimum. So that number two is basically saying you just need the public needs to have adequate time to receive the notice. And next slide, please. Notice must be posted in a location where a member of the community could become aware of such notice. So the usual methods: internet, newspaper, bill posting. Okay, this board focuses on the internet. It's the World Wide Web. We don't post notices in the newspaper, but it's still allowed. You can move to the next slide, please. All right, another Attorney General opinion. Really, this goes back to the how reasonable is the notice. So you have to reasonably describe. That's the first prong. Reasonably describe the contents of the agenda or the meeting and what any proposed action. You have to give adequate, reasonable time, and you have to post it in a location that's accessible to the public, which in our case would be the internet. And that's really all that opinion goes into in just more detail. Same with this case. It's basically saying, the case says, under the totality of circumstances, we're going to look at it. If there's an issue with adequate public notice, a member of the public has a problem or initiates legal action against not having notice against something, whether it's an application or whatever it is. This is going to be the governing case, and it basically says that, yeah, you have to have the three prongs, which is the reasonable description of the contents, the proposed action, the location where you post it, and the at least 48 hours beforehand. This just goes in and says, if there's an issue, if there's a gray area, we're going to look at other factors as well. So if there's more, if you look at the three prongs, and let's say the notice did number one really well, like it was really descriptive in the description, but they just barely made the 48 hours, or there's some question whether it wasn't posted, then the court may just get rid of that factor and decide, well, you got 1 and 3, so 2 wasn't quite there, but it was pretty close, or something like that. It's a totality of circumstances analysis. And you can move to the next slide, please. As I mentioned before, if the Public Meetings Act is not followed, it would just essentially mean whatever discussion, whatever outcome would be null and void. Again, I use the rulemaking hearing as an option or as an example. So if I conduct a rulemaking hearing and I don't give proper notice and it's questioned at some point, then they would be deemed null and void, and I'd have to start back from the beginning. So, let the sun shine in. All right. In a nutshell, the Public Meetings Act is designed to make sure all board business is conducted in a way accessible to the public. It applies to you both as an individual member and collectively as a board. And we can go to the next slide, please. In a nutshell, all gatherings of more than one member are meetings and are covered by the Public Meetings Act, including regular, special, and emergency meetings, and including committee and subcommittee meetings. The only exception is the executive session, which is your opportunity to ask your board attorney questions, but you may not deliberate or decide. Again, the executive session will only apply in face of litigation or pending litigation. And for every meeting, you must give adequate public notice and content, location, and time. And we can move to the next slide. Nutshell, if you violate the law, any violative acts are void. Cost of litigation may be assessed against the board. All right. You may think back to your board member orientation, where this was most likely mentioned. This is there's a little in the board orientation manual. There's a little snippet about this case, and this is a federal Supreme Court case. If you have more time, you'd like to read that case, please go ahead. It's an interesting one too, but yeah, great. Get the popcorn going. But this case it's really about unreasonable restraint of trade, and that's really what you don't want to get into as a board, is restricting people's ability to work. So in this case, the board was made up of dentists, and they were essentially saying that the non-dentists out there that conduct teeth whitening, the board made a decision that they're not allowed that these non-dentists are not allowed to do that. And that's a problem. I mean, it's if you as a board member or as a whole are leaning towards making any sort of deliberation or decision that will affect someone's ability to work, then legal should be involved for sure. But again, we have parameters in place here. We have folks that watch the board meetings to look for things. So if this board ever is getting to that place, I will know about it pretty soon. And Roxanne and I try to keep everyone on a straight path as well with that. But move to the next slide, please. So this goes into the fact summary I just mentioned. The state action immunity. Now, that's something the board argued for. Generally, it could apply where the board would be immune to certain decisions that renders harm or is otherwise proven to be an unreasonable restraint of trade. But this case is basically saying don't count on it. So it really needs to go before legal if there's any question on whether a deliberation or a rule is going to affect someone's ability to work. Now, I'll do my best to keep this board on the right track there. This slide here is talking about the supervision. So this comes in with the state action immunity defense. So if you think back to that dental examiner's case, the board tried to say, well, we're not subject to any civil damages, or we're immune from any damages based on the state sovereign immunity. And what the court found here is that the board did not receive active supervision by the state. So again, this is active supervision. This board, in the case, they kind of made this unilateral decision to not allow these non-dentists to perform teeth whitening. I guess there was not a lot of oversight, But again, as I mentioned, there are people in our department that watch meetings and to kind of see where the deliberation was going, what rules being presented, that sort of thing. So there is active supervision by the state here with our department. So again, if this board is discussing anything remotely close to unreasonable restraint of trade, I will stop. I will pitch in. So you'll hear from me. This slide is also talking about active state supervision. So really, you have to see the commissioner of the department. It doesn't really mean like the commissioner for the department has to have a say in the day-to-day activities of individual board members or the board itself, but the designees connected to the commissioner, that would be considered active supervision. So like I said, this department has that active supervision in place. 4-4-1265, this is the supervising officials. Again, this goes over what I essentially just mentioned. The commissioner is, you can go back just 1 second in case they want to see the statute. So who's the supervising official? The commissioner or chief executive officer of the administrative department under which the regulatory board operates or to which the board is administratively attached, or the commissioner or officer's designee. So it doesn't have to be just the commissioner of the department has to be involved in the day-to-day activities. It can be a designee, assistant commissioner. -4-125, it's just specifying each supervising official shall ensure that the actions of the regulatory boards that displace competition are consistent with a clearly articulated state policy. Next slide, please. And that's, like I said, it's have certain parameters. We have people that are looking out over this board, watching over the board meetings to make sure that the discussions don't go where they shouldn't be. So this is this statute basically puts out the steps that if someone has an issue that is saying that unreasonable restraint of trade is occurring, then this is the process that they would need to follow. Provide notice to the board within 10 business days that the action is subject to further review. Review evidentiary record regarding the action. Rules, they would look at lines or anything that was discussed. They would look at the final version of the red line and the regular rules that was voted on and approved. So that's what they mean by that. So conduct a review of the substance of the action de novo and on the merits. It means de novo just means they're going to start anew. So they're going to look at everything and see what the evidentiary record reflects. And that's pretty much it. And then after that, as with anything, in writing, the board will they'll approve the action, remand the action, or veto the action. So the supervising official will conduct the full evidentiary record, and then in writing, they'll approve it or remand it or veto it. So that's all I got on that one. Any other slides? And that's it. We made it. I tried, yeah. I'm trying not to cough.
But one more time.
I'll read it backwards. We'll start with slide 44.
Yes.
Well, thank you.
Members, we are done unless you have questions regarding the Sunshine Law or anything at all. If you do not, I know you're tired and hungry and have a ways to get back home. We would entertain a motion to adjourn.
Second.
We have a motion by Patricia and a second by Dave. Thank you so much. It is 12:30 on the dot. So appreciate all you do for the industry and the board. We are adjourned.
There you go.